Good morning, everyone. Good morning, welcome. We're going to get started right on time here. So just a couple of housekeeping items. If you need the restrooms, they are out the door and to the right in this room. We do have breakfast available, so there's two kinds of muffins. There's coffee and tea. Help yourself. Feel free to get up anytime during the presentation. We do ask that you keep your masks on unless you are actively eating so that we're protecting everybody in the room. If you are online with us today, we welcome you and we will be responding to the chat. So if you have questions, you can send a chat. You can also send an email to info@mjsterncpa.com. If we don't get to your question today, we will respond to your emails tomorrow or the next day or maybe even later today. So chat or email is available. We'll try to answer as many as we can. If you have questions you would like us to address in the Q&A session at the end, there is a red bucket up here somewhere with questions on it, so you can deposit your questions in that bucket. We appreciate La Casa de Cristo today hosting this event and live streaming it and recording it for us. So I think we owe them a round of applause for hosting us today. We do encourage you to see the sponsors that are here. And also, if you're online, you can check out their websites. And the list is in your handout of all of our sponsors. I will tell you that Church Loan Consulting LLC has a free book for anyone who's here today. So just stop and pick up the free book. And it's a great book about church lending. So even if you don't need it now, sometime you might need it. So we encourage you to pick that up. And with that, I would like to introduce Pastor Jeff Ruby, who is the senior pastor here at La Casa de Cristo, to open us up in prayer.
Welcome, everyone, and welcome to La Casa de Cristo. And important information for you, if you need it, the restrooms are out in the entranceway where you came in. So we welcome you, and we want to begin with a word of prayer. So if you would pray with me, please. Almighty God, we give you thanks. We give you thanks for the ability to gather in person and also online. We are the church everywhere, and we are grateful for that. And we are also grateful that you do not define us or limit us, but give us the gift of your church. In your word, it tells us that many are given different gifts. Some are apostles, some are teachers, some are prophets. And we thank you for the wisdom of the people that will present today. And we also thank you for the ability to learn and grow together. So be with us, guide us by your Holy Spirit. In Jesus' name we pray. Amen.
Good morning. My name is Bob Brown. I'm with the Church and Ministry Law Group. It's great to see so many friends and hopefully new friends, although I can't say that I recognize many of you behind those masks. I'm not doing too well with this identification feature. So we are just delighted to have you with us both in person and online, and we want to thank our sponsors again who have been with us now for many years. Great to see you all back. This morning we are taking a little bit of a different tack. I've got two other speakers who will be joining from our Church and Ministry Law Group. And we wanted to do that, number one, to introduce you to the concept that we have developed at Schmidt-Schneck, which is to have a whole, literally a practice group now supporting the efforts of nonprofit organizations with special emphasis on church and parachurch ministries. So our first speaker this morning will be John Rubalid. John is literally a nationally recognized nonprofit tax expert with expertise also in employment law as well as intellectual property and in general nonprofit matters. He's been representing churches and ministries for almost 30 years, a graduate of Dallas Theological Seminary, with a Master of Theology. He was a law graduate from the University of Minnesota Law School, and I was particularly impressed with John's ability to bring a practical approach to these complex legal issues. So John has been doing other seminars around the country and is up to date on the current developments in the law, and so I've asked John to come and give us a kind of a quick overview of some recent area updates. John, welcome.
All right, good morning. This is my kind of day. Like, what the heck? We get to talk about taxes. Church, nonprofit law, taxes for a few hours. Like, can it get any better? All right? So before Monica launches into that, as you see, I have an outline that provides just kind of a few topics we can go through. I'm happy to respond to any questions as we go through, but kind of wanted to hit some of these things that kind of relate to COVID, as well as some current legal issues that would be of interest to you. The first thing I want to talk to you about is the need for a remote worker policy. As COVID has caused a lot of organizations and churches to have people start work from home more, or full-time, or part-time, it's important for purposes of managing compliance and risk and performance to think about things that provide clarity and establish expectations around people who are working from home, right? So, for example, what's your expectation about their availability, the flexibility they have, what hours are they expected to work, how are they going to be reviewed for their performance, who's eligible to work from home, what technology do they use, and how do you manage the information that they have on their devices? So how do you expect them to communicate with you? So these are all issues that should be set out in a remote worker policy to manage that compliance and risk. How is that person managed? Have a language in your policy that says that their right to work from home is at will, just like their employment, so it can be taken away at any time based on your decisions. So you kind of want to have that, a remote worker policy to create expectations, minimize misunderstandings, and failure to fulfill their responsibilities. You want to focus on outcomes, workflows, and processes, right? So it's kind of the first issue that I think has become of more importance as people have been working from home during COVID. The second thing is, like we're doing today, right? Things are being streamed, live streamed, recorded, video. More information is being made accessible online, right? Like for many of you, your church had very few viewers or may not have been live streaming before COVID, but now it's a thing, right? Everybody expects to be able to watch their church service from home. So you want to have thought through what are the intellectual property issues with regard to live streaming, your CCLI, your intellectual property license. You want to think through if you have a special speaker, and that speaker has rights in books, materials, presentations they've done. Have you gotten them to agree that you can live stream or record it or put it up for viewing later on demand? So those are all things that you want to make sure are clear. And I encourage you, for people who are going to be on a live stream or a recording, to get their consent, or at least give them the opportunity to waive their right to privacy or viewing of their information or presentation, or at least give them the opportunity to opt out of being recorded. So those are intellectual property issues that you really need to think through when you are live streaming. For example, most of the times your music license doesn't permit live streaming on the standard license, right? So you want to make sure that you've checked that box so you don't create legal liability. The third thing I wanted to raise is scope of corporate purposes and mission statement. I was just in a meeting last week with the National Association of Attorney Generals and the National Association of State Charity Officials, and it was interesting to me that whenever they're very complaint-driven, right? If somebody has a complaint about how your church is operating, or they have a disagreement, they're disgruntled with a nonprofit ministry, the first place they go is not the IRS. The first place they go is with your state Secretary of State, Consumer Division, Attorney General, depends on this, on what their issue is in Arizona or other states. And the state charity officials that presented said the first thing they go to is what is the scope of purposes or mission statement that the organization has, right? So we're working on an issue in our law office right now where a organization, their purpose in their articles of incorporation are to preserve religious material. But they want to distribute it, sell it, right? Have it available in different forms. Well, that's outside of their corporate purposes. And if you act outside of your corporate purposes, then you're acting outside of your authority as an organization. And if you have raised money because this is your purpose and mission, and then you use that money for something else, your state charity official, the Arizona Attorney General, cares about that. And so that's one thing that as churches in COVID, time of COVID, have kind of expanded into trying to do other outreach or other type of activities. You want to review your articles of incorporation, your mission statement, the material that you put out there is on your website about what you're doing to make sure that you're acting within the scope of your purposes and authority. So that's become an issue, and I found it really fascinating the way these attorney generals and state charity officials were walking through the issues that they were dealing with or the situations they were dealing with, and how that's the first place that they went was their statement of purpose and mission. The fourth issue on my list is kind of return to work and mandatory vaccinations. There's been a lot of talk about the OSHA emergency temporary rule that is expected to be issued where employers of 100 or more must require people to be employees to be vaccinated. That rule was sent by OSHA to the White House last week. It's at the White House, and it was anticipated to be released quickly, but now, just on some discussions I've had, there is pushback from businesses that don't want that rule released until after the holidays because of consumers shopping, losing employees. So that's on hold for now, so we'll see where that comes out. But as you know, federal employees are required to be vaccinated by November 22nd, and federal contractors by December 8th. So the rule that would come out, and I don't know that there are any organizations here with more than 100 employees, but the rule would be a temporary rule, which means that it can only be effective for 6 months. So then they would have to go through standard rulemaking to get that implemented on a full-time basis. So that's kind of the return to work mandatory vaccinations. I think that one of the struggles both that employers, churches as employers have, is how would we enforce that? In states that require that, which Arizona doesn't yet, how would we enforce that? Who would pay for that? Those are all issues of concern. A bigger interest, I think, to churches and religious organizations is the issue of religious accommodation to vaccine mandates. And I think that is kind of interesting and challenging topic. As you know, the Equal Employment Opportunity Commission in Title VII, there is a religious accommodation for sincerely held religious belief. And so the presumption under the equal employment rules are that you're to assume that the person does have a religious accommodation, that sincerely held belief. It's only when there is a reasonable cause that the employer has that it may not be sincerely held that they can inquire into it more deeply. And so then if that person has that sincerely held religious belief, the employer is to provide a reasonable accommodation as long as it doesn't cause an undue burden on the employer. Now, I know that there have been a number of churches who have said, we're being asked to write a letter that says that our parishioners, that are our attendees, people who come to our church, church members, have this sincerely held religious belief, right? So as I look at that, I want you to understand a couple things. One is that there are two manners in which that sincerely held religious belief is presented. One is it a belief of a particular denomination or of a particularly religious group? Does that group have that belief? Is this for example, Christian scientists who don't believe in medical treatment, but that the matter of physical health is aligning your souls in the right way with God? Or a Jehovah's Witness who don't believe in blood transfusion. Those are religious group beliefs, sincerely held beliefs. The other category is an individual person's sincerely held religious belief. So my thinking on this, when it comes to if your pastor or your church is being asked to write a letter, if your church has that group religious belief, then your pastor can write that letter. But if it's an individual belief, then, for example, is your pastor telling everybody in the church that they should not get vaccinated? Is everybody in your church not getting vaccinated? If not, then I don't think that your pastor or your church has a responsibility or should write that letter for that individual. I think that your pastor can say any sincerely held religious belief that a person has should be accommodated by an employer. That's as much as I think they should say. To say more is not representing the church or the religious organization's belief. All right? So I think that's presented a challenge, and I think that that's how I analyze that when it comes to the requirements for religious accommodation. My sixth topic is governance is needed now more than ever. And so it's a responsibility to review your bylaws of your church to make sure that your leadership, your governance body, your elders, your board of directors, your trustees are following those bylaws. If they're not, why? Well, it's because we've changed the way we approach things. Then you need to make your bylaws be consistent with that approach, right? As long as it's within the law, so that you're acting within your corporate authority and the decisions they make are binding on the corporation, and the elders are not exposing, or directors are not exposing themselves personally because they're acting outside of their bylaws. So, governance is needed now more than ever, right? Think about the number of decisions your board has had to make in the last year and a half, right? Like craziness, right? Like, are we having church? How are we going to have church? All those kind of issues have been of significance, and it's now more than ever you should review your bylaws. Yes? Where does your church find your bylaws? Yeah, they're in the box in the back of the secretary's closet, right, with the dust on it. But that's a legitimate question. And I would say, if you can't find your bylaws, right, then create new ones and adopt new ones so you have them, okay? And you all have Bob's number, right, because he does bylaws, right? So that's an important step. The seventh thing kind of goes along with that, and that is what I've experienced especially in the last year and a half. I actually wrote an article on this 3 years ago. Does your state law allow you to vote your board to vote by email? The answer in Arizona is no. So you can't just send out an email and and have everybody respond and talk through the issue and vote by email. Okay? So I'm finding that churches and nonprofit organizations are doing that increasingly, and it's not binding on the organization in Arizona. You can have in-person meetings. You can have remote meetings by electronic telecommunications by which all participants can hear and talk to each other. Hello, Zoom, right? And like, how many are now Zoom experts, right? Like, hello. Or you can have a unanimous written resolution where everybody signs, right, that they have, based on the resolution, everybody signs that resolution. You can have multiple signatures, multiple copies, multiple not versions, but multiple pieces of paper, but they're all signing, and it's unanimous, right? So voting by email is not permitted under Arizona law. Number 8, just want to point out that pastoral burnout is up. COVID has exacerbated that, and so it's a reason why churches should think more about succession planning. Number 9, as churches have met less in their building, some churches have not had the revenue that they have had previously, so they begin to rent out their facility for different uses. Understand there are several issues with a commercial use of a church, and that is it may affect your property tax exemption. It may be unrelated business income, taxable income for your church. It may subject you to public accommodation laws. Public accommodation laws say that you can't discriminate, and discriminate's not a bad word, right? It's a word that means make a selection of one over another. You can't discriminate on who uses your facility if you're subject to public accommodation laws, and maybe increased exposure, liability exposure because of personal injuries. So those are all kind of 4 top issues when it comes to commercial use of your church. Number 10 on my list is religious freedoms, hiring practices, and ministry activities. I thought this case that I present here, Billard versus Charlotte Catholic High School, was an interesting case. It was decided September 3rd of 2021 in a federal district court for the Western District of North Carolina. And it was a drama teacher who had taught at this Catholic high school. And he had resigned in 2012, and he was teaching part-time. He was a substitute drama teacher. In 2014, he posted on Facebook that he was going to marry his partner, a male. And so the Catholic school assistant principal notified him that he no longer was going to be used as a substitute teacher. He sued for sex discrimination under Title VII, and the court just decided that for him, and for 2 reasons. One is based on the Bostock Supreme Court decision, which said that any issue related to a same-sex, gender identity, sexual orientation was a decision based on sex protected by Title VII, although the Supreme Court recognized and affirmed that religious organizations have religious protections, most namely ministerial exception. The court in this Charlotte case said that this person was protected by Title VII, discrimination on the basis of sex, and he didn't have responsibilities for providing religious education to the students. The church argued that he was terminated for his beliefs in supporting same-sex marriage. And the church lost at the federal district court level. It will get appealed, but there's lessons there. If you have, and you should be concerned about protecting your religious freedom rights in hiring practices, contact us, and happy to do what I call a religious freedoms audit of your church's core documents and employment practices. Thank you. Any questions? Yeah, thank you.
Thank you, John. If you have please feel free to wander over to our table, and John or Michael Edgell, who's also here with us as an employment law, will be happy to chat with you. In fact, while we're at this stage, let me introduce some of the other members of our team. Just quickly, if you guys would stand, Michael Edgell is here. He does a lot of employment law, also probate and trust, and employment litigation, and can assist with estate planning. Next, Nick Johnson is our newly minted, just passed the bar but hasn't been sworn in yet, Uber law clerk. Don't ask him any questions. Well, actually, you can ask him. He'll answer them happily, so don't ask him. Also, we have Mark Dickerson is here. Mark spoke last year, does nonprofit policies and procedures, religious liberty issues, and business transactions. Mark was senior legal counsel at Azusa Pacific for 25 years, and when he says he knows policies and procedures, he ain't kidding. He's got a lot of experience in that area. And let's see, we have Lacey Cooper. Would you like to come on up? While she's coming up, I'll give a little bit of background on Lacey. She'll be our next speaker. 15 years as a county and federal prosecutor. She came to our firm from the U.S. Attorney's Office, where she led a team of people on the board as the Border Security Section Chief. She's prosecuted cartels, gang members, and other miscreants. As a deputy chief county attorney in Payson, Arizona, she has prosecuted child sexual predators and successfully tried cases against child molesters and photographers and pornographers. She has trained law enforcement and community partners on what to do when a child discloses sexual abuse, and she now advises churches as part of our team at the firm. So we're just delighted to have Lacey with us. And I would also point out, while she is coming up, part of the handout in your packet is a great how to identify and prevent child sexual abuse. Lacey will be walking through that with you. Of the pieces that I've reviewed personally over the years, I think this is one of the better ones that you might consider handing out to parents, as well as your Sunday school teachers and others in the church, simply because it's so intensely practical but still faith-based. So, and also Lacey will be around during the breaks. You're welcome to come by and ask questions. So, Lacey, would you come up and give us some sobering news?
Yeah, right. We wanted to save the more happy topics for the afternoon, so they brought me in the morning. So as a federal prosecutor, you're not allowed to leave the podium. You can't walk around the courtroom, so this feels very comfortable to me. As long as I am touching the podium, I'm safe, I'm okay. I was the perfect Christian kid growing up. It's not really much of an exaggeration. The one time I remember getting spanked was I got lost in the Baptist church in my hometown, and my mom couldn't find me. She was scared, so she spanked me. The one time I remember getting grounded, I left my school backpack at church after I was volunteering there, and my dad had to go back and get it, and I grounded myself because I felt so guilty that we had to turn around and go back and get my backpack. I knew all of the Salty songs growing up. You all know what I'm talking about. Listened to Michael W. Smith and Stephen Curtis Chapman, and didn't watch any PG-13 movies, and I judged those who did. I didn't say any cuss words. Literally, I guarantee you I did not say a single cuss word until I was like my late 20s, because at some point I realized that I was on a streak, and there was no way I was going to, break my streak. So I will never say profanity. I was strong and independent and pretty introverted. And I will tell you right now that I would have been easy prey for a sexual predator. My parents, like all good Christian parents, wanted to shelter me and keep me in a bubble and not tell me that there are bad people out there in the world. So I didn't get an education from my home that there are people out there that potentially would want to take advantage of me and groom me. When I came of age, my mom gave me I think it was a Dr. Dobson book, and the title itself made me so embarrassed that I went to my brother and I said, "What am I supposed to do with this?" And he said, "Mom just wants you to think that you read it." So hold on to it long enough for her to believe that you got through the whole thing, and then you can hand it back. So that's what I did. I didn't actually read this book, and we just didn't have conversations about that. Came from a Southern, Baptist family, very private. I was not educated that there are bad people in the world, and I'm here to tell you today that if you do not have these conversations with your children, they will become prey to sexual predators. I want to give you a very specific example from my life. I was not abused, and the only reason that I was not abused is because of the grace of God and the fervent prayers of my mother. I will tell you that right now, because there were so many opportunities for me to just be lured away by somebody, and naively thinking that they just wanted to be my friend. But one example I just think is powerful about how easy it is for a child to be groomed and a naive Christian child to think that everybody out there is safe. So I was at home, it was junior high, friends. And my dad was in the living room and I was in the kitchen. It was one of those great rooms, so it was just kind of one big open space. And a telephone call came on the home phone. That was before we had cell phones. And my dad said, "Oh, you can get it." So I answered the phone. And this guy on the phone wanted to kind of conduct a survey of me. And so he started asking me some questions about what's my name, how old am I, what grade am I in, what color eyes do you have, what color hair do you have? And then he asked some questions about colors of hair and other parts of my body that he should not have been asking about. And it didn't dawn on me. It didn't dawn on me at all that would be an inappropriate question. And he asked about my mom, and then he asked me to confirm. And only then was I like, well, I'm not going to be able to do that. My dad's 20 feet away. I'm not going to be able to confirm, but I can answer your questions. And so I finally was like, "I'm sorry, sir, I'm not going to be able to," guiltily, "I'm so sorry, I'm not going to be able to finish your survey," and hang up the phone. I did not go and tell my dad that this strange conversation, had occurred. I mulled it over for months, thinking something about that made me feel uncomfortable, and I finally told my best friend, but again, I was 13, 14 years old, and it did not register at the time that somebody was trying to groom me on the telephone while my father was just, 20 feet away. I was easy prey for a sexual predator because nobody told me that there are bad people in the world who would want to groom me to have these difficult conversations, to lure me. And I'm here to tell you that there are bad people, and you cannot fully shelter your children from the bad people that are out there, from the bad people that are on your church campus, right? Cannot fully shelter your kids. So, Lacey, is there any hope in this message? Yes, there's some hope. Let me tell you what it is. You have to give your kids a voice. How different would it have been if I felt like in that moment that I could go to my dad and say, "Gosh, Dad, this weird conversation happened. I just want to tell you about it. I don't understand it, but I feel uncomfortable." You have to teach your kids that if there's something about an interaction with another human being that makes them feel uncomfortable, that they need to come tell you or a trusted adult about it. If they see somebody else, a friend or a peer, who, something's not right, they need to go tell their parent or a trusted adult about it to intervene in that other child's life. I'll give you another example. I had a very good friend growing up who was very, very smart girl. We were in, the AP classes and that sort of thing together. Around junior high, her personality changed. She became more dark and brooding, and she was hanging out with the goth kids and started dating a guy. And I was very naive, so dating was totally outside of the scope of my understanding. So we kind of parted ways a little bit, but we were in a guitar class together, and I saw that she had some marks on her arm, and I was like, what is that? What happened? And she told me that I wouldn't understand. So she wouldn't explain to me what was wrong because I wouldn't understand. And you know what? She was 100% right. There's no way that my little, naive bubble, Christian bubble brain would have understood what she was going through or why she was cutting. But if someone had told me that if I see marks on a friend of mine, that I should go and say something about it. Gosh, wouldn't that have been a different experience? I could have been the hero in my friend's life, not by fully understanding what she was going through, but understanding that what she was going through was wrong, and that she needed help, and I could have gone and spoken out on her behalf. Friends, we have to be teaching our kids that they need to have a voice and speak out for themselves, for their friends, for their cousins, for their neighbors. We have to give them enough information to identify, to have spidey senses, when something doesn't feel right, when a child is being isolated by an adult, when they're being groomed. We have to give our children a voice in order to protect themselves, because we are not going to be able to protect them all the time. There is a handout that I put together that I think is very helpful for, it's targeted to Christian parents. It's targeted to my parents, right? To Christian parents who want to shelter their kids, and just to be a wake-up call. Hey, you're not going to be able to completely keep your kid in a bubble. You have to do some work to give your kid a voice. So please feel free to distribute that to parents at your churches and congregations so that we can keep our kids safe. Thanks.
Testing 1, 2, 3. Okay, I guess we have the mic on this time. It may help. I have one other team member I want to introduce you to just quickly. We're just thrilled to have Alana Hake, if you'd stand. Alana and I met when I was at Gallagher and Kennedy. She was a partner there, a senior associate, works on nonprofit and church issues, a great draftsman and transaction person, and also has extraordinary depth in environmental hazard laws and so forth. So turning next to what has been in my practice kind of a surprise, frankly. Over the last 2 years, we've handled 7 church mergers. In the preceding 20 years, I had only done 2. I feel like the COVID event was part of that, but it's a little bit more complex demographically. And so I thought this might be a worthwhile topic to share with you, because I find that when clients come in, there are some pretty fundamental misunderstandings about what a church merger is. And when I chatted with Monica about it, she confirmed that assumption, that we probably really ought to talk about it briefly. So we'd like to just share some of the 100,000-foot level concepts so you'll have the grammar and be able to talk about this topic of when churches merge. There's a right way to do it, and there's a wrong way to do it. And unfortunately, there are several wrong ways to do it, and we'd like to help you avoid those if possible. The word merge in this conversation means to cause to combine, to unite, or to coalesce. I want to first of all say that the word merger is a technical legal term among the most of all misused terms. So when we speak today, we'll be talking about uniting congregations and then picking the right legal word to describe how you're going to document it. Why merge? Well, typically, the clients that come into the office, one of them is struggling financially. Not always true, but often true. The other major cause is declining attendance. We're seeing the aging out of America. We're seeing sometimes one of the congregations has lost its lease or lost its property or has outgrown its property and needs to find a more suitable place to hold worship services. We've also encountered situations where the senior leadership has frankly just gotten, in my tender age, I hate to say it, but in their 70s, and they're just tired. One of the pastors just said to me, "Bob, I'm just burnt out, tired out. I want to have a young pastor come in who's got some energy. Let's see if we can make this happen." So the lack of succession planning has contributed to this as some of our senior leaders are aging out. The congregation may be aging out. It's remarkable. One of the mergers we did recently, and I'm not exaggerating this number, the average age of the congregation was 81. That was the average age. There was one 40-year-old guy in there who drug the average down. But there were several 90-year-old members of the congregation who were still actively attending, but you can imagine what was missing. There was no Sunday school. There's no young energy coming in to help fill the pews. They had a paid-off campus. It was starting to need some repair, but they just had run out of people. So when we speak about doing a merger, we have to make some legal assumptions and some that are based on the factual situation. First, we are going to assume for this discussion that both churches are corporations, that neither has a pending or threatened litigation going on, and three, that there's no criminal investigation pending. I've seen one situation where assumption number one was not correct, in that one of the congregations, amazingly, was not a corporation. It was just a group of people worshiping together. That's becoming increasingly rare. If your church is in that situation, please come see me afterwards because we need to talk. There is literally no good legal reason to not be incorporated or be a limited liability company. But you do not want to conduct an activity of this sort unless you have a limited liability entity, one that protects your personal assets against claims. These would be claims that arise from the operation of the church, and especially if you're transporting people or if you have young people who could possibly be the victims of sexual abuse. Other assumptions include that there's a mismatch between the assets, the amount of cash, the land, the personal property, versus the size and needs of the congregation. So, for example, one of the mergers that we did recently involved a young congregation, about 200 people, and they were worshiping in a gymnasium and had grown over about 5 years to reach some real vitality. There was real energy in this congregation, a lot of young families, a vibrant Sunday school program, and within 5 miles of them was a congregation that had literally aged out. They had lost their senior leadership. They had a campus that was multiple acres, beautiful campus. All the debt had been paid off, and they were running out of people. They were down to less than 30 regular attenders. And when COVID hit, that just pushed them over the brink because they weren't properly equipped to conduct webinars and so forth. So it was literally an act of the Holy Spirit that these congregations were able to come together. So again, assumptions that you have to evaluate when you're considering this is one of the congregations typically will have a strong attendance base and have young people and a Sunday school. Here are some assumptions that you will have to wrestle with and work through, and that is where the staff comes in. Can the combined congregations be served with less than all of the current staff? If that's the case, which staff will be retained and which will have to be let go, and how will these decisions be made? And you can imagine the angst that begins to arise in a staff when these merger discussions are starting to come up. So I caution you that probably some of the most important considerations in this idea of joining congregations is the careful and thoughtful handling of these discussions so that you don't create unnecessary disruptions and angst among the staff. A related issue is how the board of directors or elders will be composed and what that process will be for deciding who will be on the board. Will there be continued joint governance? Will the congregation that's coming in with more members have the sway? How will you pick the senior pastor? Who will the senior pastor be? And will there be a tiebreaker? Will there be some kind of veto for the congregation that's disappearing? These are all topics that are somewhat on the table as you begin these discussions. This is likely to continue to be a topic that we'll deal with over the next few years as we see the population age out and also, in a sense, start to decline. Arizona particularly has a lot of folks in the elderly category. So there are two key elements as we look at the overall merger process, and they are, number one, church culture, doctrine, and politics. So, for example, would you think that a Lutheran church could merge with an Assemblies of God church? Well, you can. I've done one, and amazingly, it wasn't, the doctrinal issues weren't actually much of an issue. There was such a feeling of commonality that those particular congregations really addressed the church universal. They really all were dedicated to the idea that they would be more effective together and that their properties could be used more effectively if they combined than was being done the other way. But I would almost say you don't want to spend a lot of money on legal fees before you've worked out the church culture, doctrine, and politics, because those are critical, and there are consultants that you can hire that will help your boards work through those conversations, especially if you have larger congregations. So you have this pre-public discussion phase in which you need to confirm the common motivations, eliminate the theological dissonance, or at least minimize it, and if one of the two churches is part of a hierarchical organization, work through getting hierarchical approval. So in some denominations, for example, it would not be legally permitted to merge that church congregation outside the denomination. In other denominations where there is less hierarchical control, you can do that, and sometimes you just need to get consent. Sometimes you don't even need consent from some of the hierarchical organizations. So this pre-public discussion period, you need to evaluate and consult with major donors, consider hiring a consultant for larger churches to help you with the process, and allow plenty of time for the discussion and the process and for people to work through the idea. This is not something you want to try to rush through or hurry up, because emotions can run deep, especially if you have congregations that have been together for decades. I mean, grandma was there, she was married in the church, her son was married there, the grandkids went through confirmation. You know, you can just have decades of emotions and connections that have to be honored. So from the legal point of view, once you have a congregation or congregations that have come in and said, look, we think we've worked out the politics, now we try to figure out how to manage the legal risks. And this is where I usually say, have you talked to Monica yet? And that's it. That's the secret code for Monica to approach the stage. So we have IRS issues, we may have restricted donations, we have accounting protocols, and what else, Monica?
Well, one of the concerns that I run into is the phone call that I get that says we're merging, and the generic nature of that statement, because it's important that the accounting and the tax rules follow what is actually happening, because it may not be a legal merger at all. It may be just one church is donating their assets to another church, and that first entity will still remain in some form. So the first thing I always have to ask is it really a merger? Just to make sure that we all understand what's actually happening.
Yeah. And let's talk about Plan A.
Okay.
So Plan A, in my world, is what's the simplest thing you can do with the least amount of legal hassle. And often that's do nothing. That's my typical Plan A. But in this context, Plan A is you have, let's say, Monica is the old church and I'm the new church. Oh, I'm sorry. Monica, you be the new church, I'll be the old church. Okay. Anyway, Monica's got all the money. See, they've got all the assets and I've got all the people. So we have two corporations. So how are we going to put those together? So, Monica, what's your favorite in that context?
Well, my favorite is that your old church just give me all of your assets. So you transfer your cash, you transfer your property, because if you read those bylaws that you can't find, it tells you what happens to those assets when your organization closes, dissolves.
Yeah.
And it's also in your articles of incorporation. So first thing, pull those out of the box and see what it says. It generally is going to say give it to another 501c3.
So that's called an asset transfer, and it's common in commercial America for that to happen. And the way you transfer the assets, you do a deed to transfer ownership of the property, and you just write a check to close out the accounts, and then you do a document called an assignment, and that transfers ownership of all the personal property from my corporation over to Monica's that's going to continue. Now, the next question that is inherent in that is, are we going to then dissolve the donor? And the dissolution is a technical term in Arizona's corporate code, which essentially terminates the existence legally of the corporation. But as long as you pay the annual fee and file your annual report, you can keep an inactive corporation alive as a legal entity for as long as you want to. If you have no need for it anymore, you just file articles of dissolution with the Corporation Commission. You may have to get a tax clearance from the Department of Revenue to make sure no taxes are owed. And once that becomes effective, that corporation no longer exists. But Monica, why would you sometimes suggest that people keep the corporation in existence?
Well, I have a perfect example of that. We had a small college that was closing or needed to do something, so they transferred their assets to a large college, and I fought and fought and fought with the board to leave their corporation alive, let it act as a fundraising arm. And just this past year, they received $580,000 estate from a gentleman who had donated $15 a year. So this was somebody, they had no idea that that estate was out there. And here it was, $580,000. The board now understands why we leave that corporation open. Had it closed, it would have gone to the state because he didn't have an alternative beneficiary or family.
The danger there, and kind of the warning maybe even for yourselves when you look at your own will or estate planning trust, a living trust, if the let's just in the simplest case, let's just say it's a will. If the will says when Bob Brown dies, I leave all my money to First Presbyterian Church of Flagstaff. And then it will often say, if that's not existing, then give it to my great-grandson John who lives in Anchorage. Well, if that corporation no longer exists, then the will is very clear. It doesn't say, but oh, if they merged to somebody, give it to whomever they merged with, or check to see if they had a successor. It says, if they no longer exist, give it to my great-grandson John in Anchorage, who's a fishing boat captain. So there's this language floating out there they could be donations, they could be wills, they could be life insurance policies that are designated that way. And when you kill off the corporation, if you do so too soon, you may very well cause that money to end up going to the alternative specified recipient and lose it. Now, the counterpoint to that is there's a thing called the Uniform Fraudulent Transfer Act. And it's sort of a topic for another day, but essentially it means if on the way home from this event today, I run over two of the brain surgeons from Mayo in the crosswalk and rack up a $40 million judgment, on the way home, I realize I don't have $40 million and I just whacked these brain surgeons. I can't give my house to my brother, give all my cash to my Aunt Sadie, and give my gun collection to my son, on the hope that that would keep it away from the families of the brain surgeon who are going to get a judgment against me and try to take all my assets, right? That's called a fraudulent transfer. It's a transfer that was made to hinder, delay, or defraud a known creditor. So these transfers that happen after a tragic event are easily set aside by a court. So you have to be careful when you're doing these church transfers, because there's a potential application of the Uniform Fraudulent Transfer Act that could cause those assets to have to be handed back to the corporation church that we thought we were getting rid of, and then handed over to the person that they injured. And of particular concern in this context, the fact that in Arizona today, the statute of limitations on sex abuse claims does not run until the person is 30 years of age. Now run that math for a second. So that means you could have a child who, assuming there's no future changes, is 5 years old today. That means that church has a potential claim for 25 more years, and they won't even know that the claim is sitting out there waiting to be asserted against them. The sex abuse area is particularly dangerous because in 2020, the legislature changed the law so that there was 0 statute of limitations. You could file a claim if you were 65 years old and you were abused when you were 5. The legislature was so incensed over the sex abuse issue that they just removed it for a year. And then as part of the compromise in 2021, it went to age 30. But if we have one or more outrageous events in the country, like the Dr. Nazar or the Penn State or any of those things, I think it's entirely possible that we may see statute of limitations in Arizona go away for sex abuse claims. So this idea of trailing claims is real. For all other claims, there's typically either a 2-year statute of limitations for negligence claims or a 6-year statute of limitation for breach of contract claims. So when you're thinking about dissolving this other entity or moving it, you just can't run a checklist. You've really got to have a thought process that's analytical as you go through it. So that brings up the next form, and this is actually the true technical merger. The first one we did actually wasn't a merger at all. It was just an asset transfer and a potential dissolution. This is actually the true merger. So Monica, have you seen where First Presbyterian merges into Second Presbyterian, and then when you do that, by the way, in the merger, First Presbyterian no longer exists. On the effective date of the merger, the old corporation literally, it's fairy dust, and it becomes Second Presbyterian.
Yes, I have seen that as well.
And from an accounting point of view, any particular issues or things we're worried about?
Well, the important thing is that if you're pursuing either the dissolution or the merger, there is a date that's associated with that. There's an effective date. And so it is important to plan for that effective date when dealing with accounting and tax issues. Calling me 9 months later doesn't help. And I've seen churches who have done things, for example, they merge July 1st, and so they go into their books and records and post all of the January through June activity for the other entity. Okay, that's not appropriate. So call first, have a date in the future where this is going to happen, and then we plan accordingly based on that date.
And we can draft the legal documents that way as well. So for example, if we were working on a merger that was going to happen now, we might say, let's make it effective January 1st.
Right.
So we can actually do the documents, sign them, file them with the Arizona Corporation Commission. All the paperwork's done, but the effective date on the Corporation Commission papers is January 1st.
Right.
So that allows us to fully coordinate it and not do it as kind of a hurry up or try to fix messes.
And Bob, they could still combine worship services if they chose to, right? So it isn't like you can't do any part of the combining of the congregations. It's just from a legal standpoint, there needs to be a future date.
It's kind of, I've often said that being schizophrenic helps understand legal stuff. And it's really true, because what you're doing with your congregations, where you're meeting, who your pastor is, who's the Sunday school, and all that can happen sort of apart from the legal structures. We don't like to get too far apart over a long time, but if it's a matter of a couple of months to help transition, not a problem. So we have basic legal forms. A corporation can also become a wholly owned subsidiary of C. Now what that means is church planting is a good example. If you were to look at the organizational chart, for example, of Christ Church of the Valley, you have Christ Church of the Valley sitting up on top as a corporation, and then you have a separate limited liability company underneath it for each of the 12 or 14 locations. And so that LLC that operates in location number 1 is a separate legal entity, a wholly owned subsidiary of the mothership. So one of the ways, if you're, for example, we recently did a merger of some Presbyterian churches where the old one wanted to stay in business, but they really wanted to unite and coalesce with the larger one. So we turned that corporation into a limited liability company and left it in place at the location. Actually, we actually formed a new one. And we left the old corporation in place to receive donations, but it just sits there basically inactive. So this is a great way to build for additional locations. So they're planning to do 3 or 4 more locations. So eventually they'll have the mothership and 2 or 3 or 4 limited liability companies underneath, each operating at the separate location. Does that cause you any heartburn?
No, but let me know when it's happening, not later. That is my, and the other thing that I would add is that please don't agree to have Bob make your life complicated unless you're willing to put the work in on the accounting side. So sometimes what happens is we see a lot of legal documents drawn up and the accounting people are not involved in that process. So it's important that the accounting people be involved in the process so that they understand what's happening legally, because the accounting needs to match what's happening legally and vice versa. And again, it's not something you call about later, because we need tax ID numbers, we need bank accounts, we need separate books, we need to address how you're going to pay payroll. So there's a lot of concerns when this legal stuff is happening in Bob's office that you need to address in your bookkeeping. It's not just a matter of setting up classes in your QuickBooks file. You need separate company files. I see some laughter from a fellow CPA. Yes, we've all seen this. So make sure that you have the capacity in your accounting department to deal with this. And then number 2, make sure those accounting people are involved at every step of the way so that you can clarify with Bob, like Bob, what do you recommend for payroll? And he'll probably say call Monica, but at least you've asked the question. So.
Yeah, and that raises the higher point. You really need to do this merger with a checklist in hand, because you want to make sure that you've changed the name on the insurance policies, for example, that you've checked with the assessor's office to make sure that's going to be done correctly, that the bank accounts are done correctly, the utilities bills, and so on and so forth. So it's not something you want to do at home at night alone, unsupervised, because there really are a lot of ways to foul it up. Notable of which, if you're going to do this on a low budget, do not form an LLC using the fill-in-the-blank form at the Arizona Corporation Commission.
I would add, do not form any entity using the fill-in-the-blank corporation forms, because they don't meet IRS standards. I've fought them for 15 years to try to get them to improve it, and they don't, so don't use the fill-in-the-blank for anything.
The real quick point is you are forming a company which is a, quote, nonprofit under Arizona's corporate law, but you're not forming a company which qualifies to receive tax-deductible donations as a charitable organization under Section 501c3 of the Internal Revenue Code, because the Internal Revenue Code doesn't really care what Arizona does. But Arizona has to care what the IRS wants them to do.
Yeah, well, you would think.
You would think. And the other thing, I throw this in for Monica, when you form the LLC, do not get the EIN by yourself. Call Monica's office and let her walk you through, because there are a couple of boxes you can check in correctly.
Yes, you can end up being required to file a corporate income tax return if you do that wrong. So it's less expensive to do it right than to try to fix it, especially with the state of IRS right now.
As long as we're talking about mergers, just the next time you're at your Christmas party, you can say, I know all about mergers. The classic merger you hear people talking about is when you have A and B and they merge into C. That's the classic merger. So A and B both go away and no longer exist, and you have a brand new corporation, and that is a technical form of merger. There really are multiple technical forms of merger. That's why, in a sense, the word is really kind of a difficult one to use until you see what people actually mean by it. So that's really a kind of a quick overview. Monica, I'm not sure how we're doing on time, if we have time for any questions.
We could take a couple questions if there's anybody who has a question.
So if you have any questions about this, we'll take them now, or you're welcome to if you're online, type it in the text
Right.
Or if you'd like to come over to our table, we'll be happy to chat with you as well.
Okay, very good. Well, thank you, Bob. Appreciate the information.
Thanks.
But wait, there's more.
Oh, wait, there's more. For $9.99, you can get a second. I wanted to mention to you that Lacey is running for Maricopa County Attorney General, or County Attorney, rather, Maricopa County Attorney. I am just thrilled to hear this. So if you have questions about that, I can't do a political thing. All I can do is just tell you I'm really happy that she's running, and you can tell by her values that you would probably be happy too.
Thank you. We'll have time for questions and answers at the break, as well as anything we don't get answered, we will email you. So if you have a question, you can either email the question or you can type it in the chat, and we're making notes and we'll respond to you. So, and if for some reason you didn't get your question answered, feel free to either email Bob or I, and we'll try to answer your questions. We would like to have that done timely, not 3 weeks from now. So, okay, do you want to answer a question?
John mentioned that Arizona doesn't allow voting by email. Does this apply to voting or approving a housing allowance by email?
The board is required to approve the housing allowance, and I believe that that should be done in the minutes and in the formal method according to state law.
So let me put a little finer point on it. If you have DocuSign or the Adobe program where you can put signatures in, you could do a unanimous consent resolution by email, the email would just be sent out to all your directors, and they would sign by DocuSign, and you would have a validly adopted unanimous consent resolution by email.
Okay.
It's a fine technical point because you didn't actually vote by email, so John is absolutely right, but you were able to get your housing allowance done without having a meeting by using a unanimous consent resolution and DocuSign.
So could someone also just print it out, manually sign it, scan it back as well, correct? So yes.
And all the signatures don't have to be on the same page. You just need to collect them all and put them in your minute book and scan them together.
Perfect. Okay.
Does that have to be unanimous?
Yes. One vote? No, unanimous is the key. It must be unanimous if you use that procedure, or no bueno.
Okay, thank you. And if you have any other questions for Bob or any of his staff, their table is back here in the corner. So, okay, so we are going to talk about first the COVID-19 benefit updates that are out there. And I don't know about you, but I feel like it was just run through the ringer last year with the constant changes in these programs and the updates, and I just heard today on the way over that there's likely going to be another bill passed today, and who knows what will be in that bill. There's also something that just posted today about allowing LLCs to be nonprofit tax-exempt organizations. So it just was posted this morning. So they've issued some proposed rules and are asking for public comment. So I can tell you what the law is at the moment that I put this together, but the way things have been lately, if you have any questions, be sure you research the most current information, and I'm actually going to have a couple corrections to my information for changes that occurred in the last 5 days. So, so yes, my job is fun. So, okay, the COVID-19 benefits, most of you are familiar with the PPP loans and those benefits. We're going to talk about some of the tax credits as well as a state benefit that we have. Some of these things have expired, some expired and were renewed, and who knows what will happen going forward. So I'll just caution you to always check the most recent information. The IRS website is not always timely updated for some of these things, so be careful that you're looking at the most recent information. So just a reminder, we had the Families First Coronavirus Response Act. This was the FFCRA. where you got a tax credit for the wages that you paid to employees for paid sick leave due to COVID requirements, or the credit for expanded family and medical leave. Now, both of these credits expired September 30th of 2021. So third quarter was the last quarter that you would be filing for those credits. They are available on amended returns. If for some reason you failed to report it, you can still take advantage of that. And you can take those FFCRA credits even if you received the PPP loan. Originally, there were some limitations, but now the credits are all available. But logically, you can't take the same wages that you allowed for the PPP loan as wages under any of these credits. So there's no double dipping on wages. So IRS requires that information be put on the W-2 form. So notice 2020-54 requires you to report on a notice or in box 14 of the W-2 if any of your employees got any of these benefits. So if you paid anybody for being off work, or you paid them because they were caring for a family member and you took the credits, it needs to be, there needs to be information with the W-2. And there's several categories that will get reported on there. As a tax preparer, please put it in box 14. Don't put it in a supplementary statement, because the first thing that people do is they open their envelope and they throw away everything in it except the W-2. And so we have no idea when they've received the benefit of these tax credits. So if you can put it in box 14, please do. You're also required to issue a model notice, and I've included that in here. You will want to get the most current one, and it's in the instructions for the W-2 forms. So the model notice obviously can be a separate piece of paper, but we do encourage you to use box 14. Okay, so the W-2 form, if you notice, box 14, this is the box you put your housing allowance in. And so we ask you if you can just put in the FFCRA leave with the appropriate codes in that box 14. That'll help tax preparers everywhere. The next credit that's available is the Employee Retention Tax Credit. Now, originally, entities that got the PPP loan were not eligible for this credit. It was just a blanket. You either got the PPP or you got the ERC. That has changed. So you can get both of these credits, but not for the same wages. Again, no double dipping. The rules for claiming this credit are very different for 2020 versus 2021, so you want to be careful that you're reading the right rules for the right period, because they're very different. And this credit can be claimed on an amended tax return. So if you filed your 941 forms and didn't realize you were eligible for this tax credit, you have up to 3 years to file a claim on a 941X. So I would not wait 3 years. I would, look at it soon. We have a number of them that we're going to do after this seminar is over, and we may do some in January and February as well. So that is available. So for 2020, and very important, remember what year we're talking about on all of these. So the 2020 credit, the eligible employer has fully or partially suspended operations due to government orders related to COVID-19. So in other words, you had a federal, state, or local, city, county, whatever order is the key word, to suspend partially your operations or fully. Or if you experienced a significant decline, which they defined for 2020 as 50% in gross receipts during a calendar quarter when compared to the same quarter in 2019. So we're comparing 2020 quarterly receipts to 2019 receipts. If you are eligible for one quarter, even partially, you will be eligible for the next quarter as well in 2020. So this is a change. There was about 800 revisions to these credits during the year, so just be aware. It was a little mind-boggling. So for example, we saw a lot of people who quarter 2 of 2020, they had a 50% decline. So if you had that 50% decline in quarter 2, you would be eligible in quarter 2 and quarter 3. So if your PPP loan, though, covers, say, the first month or 2 of quarter 2, you would only be able to count the wages after your PPP period. So you might have, might count June and then all of quarter 3. So be careful with your dates and make sure what your covered period was when you did your PPP loan and exclude the payroll during those dates. So for 2021, it's significantly different. So the first part's the same. You have to have government orders. That's the same. Or you experience a significant decline, which is only 20% in 2021. And again, you're comparing to 2019. So this is much more generous in that a 20% decline we see much more commonly. And you're comparing to 19. So for quarter 1 of 2021, you can elect to use quarter 4 of 2020. And for quarter 2, you can elect to use quarter 1. So a little bit confusing, but just know that this is out there. Now, in regard to churches in Arizona, and I realize some of you online may be from other states, so you'll want to check what your state did. If, for example, in California, the rules were much tougher than they were here in Arizona. So Governor Ducey did not shut churches down. Now, some other operations at churches, such as daycare or preschools or grade schools, could potentially have had some shutdown orders. So you really need to research the shutdown orders that relate to whatever your ministry or church was doing. So, but churches themselves were not shut down, and they were deemed essential services. So my firm was never shut down. We were deemed essential service. We were never ordered to shut down. So you have to know whether you actually had orders. It's not just suggestions or to comply with CDC recommendations. It has to be an order. So it's unlikely that Arizona churches will qualify under that first category unless they had an entity like a preschool or a daycare or something that would cause them to be partially shut down. So for both years, you have to look at how many full-time employees that you had in 2019. So if it's more than 100 employees that are full-time in 2019, I'm going to guess that we don't have a lot of people with 100 full-time employees. You can only count the time when employees were not working. Okay? But if you're 100 or fewer, it's all the wages paid to the employee, whether they were working or not. And for purposes of this credit, full-time is 30 hours. One little catch on this, and that eligible wages have to be subject to Social Security taxes. So clergy does not qualify. Clergy and housing do not count. Now they counted for the PPP loan, if you'll remember. They did count for that. For this credit and a couple other things we're going to talk about, they do not qualify. And again, you can't double dip. So for the 2020 Employee Retention Credit, it applies to wages and health insurance paid March 12th through December 30th, 2020. And the credit is 50% of the wages up to $10,000. So in other words, plain English, a $5,000 credit per employee, but that $5,000 is for the entire period March 12th through December 31st. And because IRS couldn't get the forms out in time, you report both quarter 1 and quarter 2 wages, or the credits on the quarter 2. And you can amend that if you need to. So be aware of that. So the most you could get in 2020 was $5,000 back from the government for this tax credit. 2021 is vastly different and new and improved. So it applies to wages for the entire year. And the credit is 70% of the wages up to $10,000, which means $7,000 credit, but it's per employee per quarter. So you can get $28,000 maximum per employee for 2021. So this credit, if you qualify, is a real bonus to churches and ministries. Now, how do you count your gross receipts? So gross receipts for tax-exempt organizations have to be counted in full, and you cannot just print out your P&L. It's not going to work, because most churches use kind of hybrid, weird accounting methods. So not all your revenue is in your revenue accounts. So you're going to want to set up an Excel spreadsheet to make sure you capture all the revenues and that you do comparisons. So contributions, donations, grants, dues and assessments if you're, charge dues. Gross sales. Now, this is the gross amount that comes into your account. No deductions allowed. So if you have a bookstore, it's not your profit and it's not deducting cost of goods sold, it's gross sales. Gross sales of investments, so if you sell stock. Dividends and interest. And it's any other gross receipts. So you have to really think about the things. So the camp fees that you're charging. And sometimes churches put, for example, they will put the camp fees that kids pay in the camp expense account. So you need to make sure that you're identifying all revenues that are hitting your account and not just what's showing up on your income statement or profit and loss. It does not include the PPP forgiveness. You can exclude that. And it's determined on the basis of accounting that you normally use. Now, most churches use a cash basis of accounting, but some organizations use accrual. So if you're doing cash, you use cash. If you do accrual, you do accrual. And you have to use the same method for all the quarters. So be careful there's certain items you want to be careful of. A donation of stock is a revenue, and that is measured at fair market value when that stock is donated. Then when you sell it, you count it again because it's the proceeds from sale of investment. So be careful with this. This is a little bit tricky. You have to count restricted cash receipts too. So if you have an accounting system where your restricted funds are on a different report or they're on your balance sheet, so if you're tracking restricted funds on your balance sheet, you're going to need to analyze those and determine what restricted cash receipts came in during the year or during that particular quarter. So be careful about that. We've had some churches who in 2019 had a capital campaign, and then in 20 and 21 they didn't have a capital campaign. So they qualify for the decline in gross receipts, even though that was kind of a special thing going on. So be sure you're capturing everything in the quarters that you're looking at. Okay, so that is the employee retention credit. There's one credit that was done. You were in 2020, you were allowed to defer the employer's share of Social Security taxes. I only have one client who took advantage of this that I know of. So what you did is you short paid your share of taxes, and half is due by December 31st of 2021, and half is due in December 31st of 22. So don't forget to repay this money. And if you were not the bookkeeper or doing payroll in 2020, I would really suggest you go look at those 941 forms and see if a deferral was taken. So, and even if you use a payroll service, just go back and look at the 941s and see if that deferral shows up. Supposedly, IRS is going to let people know. Do I count on that at this point in time? No, absolutely not. So make sure you are aware if you took this, and don't forget to repay it, because there's big penalties involved. Did anybody do this that they're aware of? Yeah, I just had one for-profit client who did it. So, okay, so you may have noticed on the 941s there's more pages and more lines. This is just kind of a summary of the pages and lines that you need to be aware of. And that deferral you'll see is on line 3, so it'll be 13B. So look at those 941s and make sure no deferrals were done. You have been through now a year where we have the W4 changes, where employees who wish to have a change have to use the new W4 form, which has been kind of confusing for people. It's the one where it asks about if you have a second job or, you know, and it encourages you to go online. So we just want to make you aware that if people want to change their withholding, they can't use the old form. They have to use the new form. And they should go online to the calculator, the estimator. It'll help them fill out the form. That's not your job, and you shouldn't do it because you need to know about the family income. So the employees, I would refer employees to this calculator. We did see some people who filled out the new form when we were doing taxes, and they messed it up, and they owed some big withholding. And they didn't realize, because they didn't pay attention to their paychecks, that things had changed. So you want to make sure that they are looking at that new form and that you're providing them with the correct form. This topic doesn't fit anywhere else, so it's related to COVID, so I'm going to talk about it. Does anybody have a preschool or a daycare in this room? Okay. Are you aware of the stabilization grants? Okay. So there is an incredible grant out there for daycare and preschools that are run by churches or not, just really any daycare or preschool that's licensed by DHS. So this is not DES, this is DHS, and it's my understanding that preschools and daycares all have to be licensed by DHS. But you have to be licensed prior to March 11th of 2021. There's a link here that talks about it. The grant is effective for 2 years, July 1 through June 2023. And there is a provision that you can't be closed more than 14 days to receive that month's grant. However, they excuse holidays, weekends, and pre-published closures like Christmas vacation, for example. So, super generous grant. The grant is not competitive, so you don't have to give them a sob story or a budget. It's literally how many kids do you have enrolled, and are you open to serve the kids without those closures. You can count operating expenses all the way back to January 31st of 2020. So in other words, if I get an August grant, I can report expenses from last spring. And it's payroll, operating supplies, it's a wide range. It does require monthly reporting of the enrollment and if you were closed. So you go in, you log in that you're still meeting the terms of the grant, and then quarterly you have to provide a report of expenses. So this is a $10,000 grant per month if you have 100 or more students. It depends on the number that you have enrolled, but once you hit 100, it's $10,000 per month. This is an incredible grant that's available to our church preschools. So if you know of somebody who can benefit from this, I appreciate sharing. I want to thank Heidi Zinn from Shadow Rock Church who alerted me to it, and I've alerted all those that I know, and it's real. So just be aware that that's out there. I feel like for a change this year, I get to have good news. I always feel like I'm the bearer of bad news, and this year I feel like there's actually some good news. So the next topic we're going to talk about is student loan forgiveness for church workers. So prior to July 1st of 2021, we wouldn't even talk about this because church workers did not qualify for the student loan forgiveness that was afforded to other 501c3 organizations. So if they worked for a religious organization, they were excluded. And this change came about because the Supreme Court in Trinity Lutheran Church of Columbia versus Comer ruled that churches and religious organizations cannot be excluded from public benefit programs simply because they're churches or they're religious. And that's most likely too why we qualified for PPP loans and employee retention credits and that type of thing. So this is an important change to this program. So if you're out there and you're saying, hey, I tried applying for this thing and it didn't work, well, it's a new day. It's a new day. So the program we're talking about is the Public Service Loan Forgiveness Program, the PSLF, and this is the program that's run by the Department of Education. Now, this is a module I had written in September, and then on October 6th, they announced even more changes, so I went back and I rewrote my module. So there were even more changes that were made to this program to make it more user-friendly. So these rules are temporary through October 31st of 2022, but they'll likely become permanent in some form. So if you have someone who might be eligible for this program, they will want to act sooner rather than later and at least get the ball rolling. So under the PSLF program, only federal direct student loans used to be eligible. So there were a lot of people who had the, quote, wrong kind of loan, and now all student loans are eligible. Now, the only ones that are not eligible is it has to be a loan of the worker. So, and that student worker has to have the loan. So parent loans don't qualify. If I go borrow from my kid to go to college and he works in a church, that isn't going to work. Or I work in a church. Parent loans are not eligible. So if you have the wrong kind of loan, you can consolidate those into a federal direct loan, and that'll make it completely eligible. So there's things you can do to fix this problem because it didn't work before under the old program. So you have to work for a tax-exempt organization. There's also government and military eligibility as well. But for our purposes, we're going to talk about working for tax-exempt organizations. You have to work full-time based on the employer's definition if that's at least 30 hours. So if your employer says full-time is 32 hours, you have to work 32 hours. If they say full-time is 28 hours, you have to work 30 hours. Can't be lower than 30. And you can combine part-time work for 2 or more employers if it totals at least 30 hours total. Now, you can't work at Starbucks for 15 hours and the church for 15 hours. It would have to be 2 different churches or a food bank and a church. So it's got to be 30 hours working for the right kind of employer. So the program requires that you make at least 120 qualifying monthly payments, which is 10 years of payments. And only payments after 10/1 of 07 count. So it's, if you had loans prior to that time, the program was started in 10 of 07. They have to be paid while working for a qualifying employer, so a tax-exempt organization, and you had to have paid the full amount due on each payment. What was happening is Department of Education was notoriously bad for sending out the wrong amounts, or not sending bills, or doing modifications late. And so students were getting penalized because they didn't pay the right amount because the Department of Ed had goofed it up. So this is now waived. You don't have to pay the full amount. There's a story I read of somebody who paid 1 cent less and was penalized for it. So this is now waived under the new rules. Under the old rules, you couldn't pay late. But again, Department of Ed was not good at letting people know when they were supposed to be paying. And so this rule has now been waived. Late payments will still count. And qualifying payments do not need to be consecutive. So let's say you work for a church, and then you decide you want to work at Starbucks for 6 months, so you do that. And then you go back to church work. You can count both of those periods. They don't have to be in a row. The payments made while you work for Starbucks won't count, of course, but they don't have to be consecutive. The amount forgiven is not taxable. And in all the years since 2007, the Department of Ed has approved only like 5,000 applications, which if you think about the number of student loans, and it's because of all these strict, unbendable rules and the foul-ups by Department of Ed. So they have said, and I say this with a complete disbelief that they are going to automatically review all of the applications that they denied previously. So they say that. I would not, if I was in this position, I would not wait for them to approve it. And again, we talked about Parent Plus loans are not eligible. So if you want more information, go to this website, and I share this with your staff because we have just seen a ton of people calling us like, how can we help our staff pay off their student loans? I've had so many calls about that this last year. And this is the way that you can proactively let them know that there is light at the end of the tunnel on those loans. The other thing that they will want to do is they'll want to be sure they're under an income-driven student loan plan. And there's a variety of student loan plans that basically say, how much do you earn, what's your family size, okay, pay us this amount. So these are the 4 different kinds of plans that are available, and I don't even know what they require, but basically the income-driven plans will require payments for 20 to 25 years depending on the plan. But under this student loan forgiveness, you can have your loan forgiven at the end of 10 years, as long as you're working for the right kind of employer. So there's an advantage to being under the income-driven repayment plans. So to reduce the payments, you can consider married filing separate tax returns because they base it on the tax return. And so sometimes, and I had one client who we did this for, that we filed married filing separate tax returns. However, be aware that Arizona and California are community property states, so you can't just report your W-2 and your spouse report their W-2. You have to add it together, report half. Each of you report half. It still will reduce your payments generally. You want to consider the cost and hassle of preparing 2 returns with the reduction in the payment. So your payment's going to be lower, and if you qualify, your forgiveness will be higher. So by making lower payments, then you can have a higher amount forgiven after 10 years. So this is something that your staff will want to plan and just make them aware of this program. Now, we had a couple cases where we had churches who paid off their student loans for their clergy and other staff members, and sometimes we found out about it after the W-2 was issued. I had one client who came in, we were doing the taxes, and we always ask a question in our tax organizer about student loans, and he said, my church paid it off for me. Ding, ding, ding. So student loan payments by an employer are taxable to the employee, unless you have a qualified educational assistance plan that offers tax-free education assistance of up to $5,250 for all eligible employees. Now the catch with this is all eligible employees, and you can't discriminate. So you can't say, we're gonna have this plan for our pastors, but not for the rest of our staff. That is not allowed under these kinds of programs. The case I dealt with, it was a $17,000 payment, so it wouldn't have helped anyway. So student loan, if you do decide to pay it off, it is taxable. The other factor is it has to be reasonable. You know, we always talk about reasonable compensation, and we're going to talk about that a little bit more. So is their compensation reasonable if you add a large one-time payment to it? Now, the $17,000 in the context did not look unreasonable, but what if it was $50,000? Would that be reasonable compensation? And so that is a big concern about employers paying off student loans. So if you have ever done this, make sure that the student loan repayment is on the W-2 form. Also remember that if you don't put it on the W-2 form, it's automatically unreasonable. Even if it looks reasonable, it's considered unreasonable if it's not on the W-2 form. Okay, so that's a great program, and just the changes that have been made. I've worked with a number of people over the years where you know, gee, it's too bad you work for a nonprofit, but you don't qualify. And so now we're on the same the same page with everybody else. So that's good. Okay, and kind of in conjunction this last year, I think Bob said he did more mergers in the last 2 years than he'd done in his entire career, and by some, and I was involved with some of these mergers, but I also had a lot of church closures, just plain old closures. I had mergers, I had people who were retiring and were not prepared for it. The reality is that you know, our staff are getting older. People Bob's age, not my age, are looking at retirement. and many of them are very unprepared for retirement. And so we just need to figure out how we can help as churches to make sure we're taking care of our people and giving them the opportunity to take care of themselves. So some of the issues we saw last year is pastors retiring, he hasn't saved. I mean, this was super common, and I had a number of cases in this case. In some cases, the church has not contributed to the retirement. So we've got somebody retiring, the church has never contributed to any kind of retirement plan. Or conversely, the board wants to bless the pastor with a large severance, many times unreasonable in the eyes of the IRS. So, you know, the time to do this is not when the person is leaving. And then we have to look at issues, was the pastor paid fairly for his years of service? So, you know, we make different decisions if somebody's been fairly compensated their entire career, or if they served, you know, at a far below market salary and benefits. So those are the conversations that we have. Churches try to attempt to make it up at the end or when the church closes, and this is a dangerous situation because you run the risk of it being unreasonable. And one of my saddest cases was a 63-year-old pastor who had opted out of the Social Security system. He had no savings. He had earned about $40,000 a year as a pastor for a very small church, and now he's facing retirement with absolutely nothing. So those are the ones that really, really concern me. So one of the problems in dealing with trying to make it up at the end is that the rules on excess benefit payments make it difficult to legally catch up on a pastor or executive's retirement. So we want to make very sure that we're following the rules for reasonable compensation. And if you don't do any of this right, that paying large sums out can subject the church and ministry and the board members to penalties and or excise taxes. So there's consequences for doing some of this. And it's a sad fact that too many clergy and ministry employees retire without adequate savings for retirement. Now, some run-of-the-mill employees do that too, but it just seems like that's not something that we should do to our brothers and sisters. So it's better to start a 403B plan, and this is the type of plan, a 403B plan. The 9 means it's a church plan. So if you're in a non-church related ministry, you will have a 403B. The 9 just means it has certain benefits for churches. So it's better to establish it at the very beginning, even if the church doesn't have the budget to contribute to it, at least allow the employees to contribute. So if you are not affiliated with the church, but you are a ministry, just be aware that there are some differences between 403B plans that are not under the control of a church. So just be aware that I'm going to primarily talk about churches, but there are slightly different rules for ministries that are not under the control of a church, but you still can have a 403B plan. So the benefit of the 403B plan over other retirement plans is easy to maintain and established. You do not want a 401k due to the issues with establishing and maintaining it. There's no requirement for the church to contribute. Contributions can discriminate. In other words, we can give higher contributions to our pastor if we want, and then do little or nothing for our rank and file, or we can kind of pick and choose how we do contributions. You can discriminate. All employees can participate by doing deferrals through their paycheck, but employer does not have to contribute. There's no discrimination testing. In other words, we can do different contributions for different people. Contributions under a church plan can be made for 5 years after an employee's retirement. So there are some benefits to that if we haven't planned adequately. And retirement benefits can be treated as tax-free housing allowances. So in other words, when our clergy retires, as a church, we can declare a housing allowance for that retired clergy to be paid from their 403B plan. So that can be a benefit. It allows contributions to the plan from the clergy's paycheck will reduce the amount of self-employment tax, it reduces their income tax, and it reduces their self-employment tax. And virtually, the money they put in from their own paycheck can really escape taxation on both counts permanently, because it can ultimately be a housing allowance. So there's a lot of benefit to clergy to be putting money in from their paycheck. So you're required to have 2 documents. The church plan document is the document between the church and its employees that spell out the terms of the plan. And if you're using a company, well, you would be using a company to help you do this, they generally have prototype plans where you can check various options to set up the plan. Like, I want to cover employees after 90 days, I want to cover employees after a year, and those options will be in compliance with the options under federal law. This is a document that should be approved in your minutes very specifically and adopted by your board. And then there's an agreement between the employee and the company holding the plan funds. So much like you go to a bank and you set up an account, the bank agrees to do certain things with your account. And so that agreement is between the employee and the company holding the employee's funds. I oftentimes see only the latter one. And you don't have a 403B plan if you don't have that first document. So then the employee can elect to make 403B plan contributions that are deducted pre-tax from their paychecks unless they're electing a Roth option. And so for both state and federal, these will be pre-tax, but they are subject to Social Security and Medicare. Of course, clergy don't have Social Security and Medicare at the employer level. The church can elect to match a dollar amount or a flat amount or a percent for some or all employees. And then you have to remit those to the 403B company by the 15th of the following month or earlier based on your plan document. Some plan documents will say within 5 days of payroll, but the latest you can go is 15 days in the following month. So common errors that churches make in this whole process is they don't ever have a plan document, or they can't find it. It's in that box with your bylaws, I bet, you know. So that plan document is really critical to deciding what you have to do, and it invalidates the entire concept. So if you don't have that plan document, you don't have a plan. So the other thing I see often is not distinguishing in the payroll system what's an employee contribution and what's an employer contribution and what is an employee elected deferral. So in other words, if I have somebody who's making $1,000 paycheck, and they say, I want to put $100 in my 403B. The gross pay is still $1,000. You're withholding $100 as a 403B, and that needs to be delineated in the pay system. You're not paying them $900 and making an employer contribution of $100. So it's really important that you distinguish what it is you're paying. And I see churches all the time that bump that gross down, especially with clergy. For some reason, they bump that gross down, and that's not appropriate. The 403B affects the W-2 and it affects other tax matters, so it's important to get this. So paying deferrals late or inaccurately. This is a raging problem in that we don't pay attention to what's being withheld and what's being paid. Those two should match. Paying contributions to the company that holds the funds based on a, quote, bill from them without regard to what was actually withheld or what the actual matching should be. The bill is only a suggestion. It's a worksheet for you to figure out how much did I withhold and what is the appropriate match. And so when you get that, quote, bill, you can't just pay it. For example, if you pay biweekly payroll, some months are going to have 3 paychecks in them. And if you're just paying what they send you every time, you're missing one of those paychecks. So we see this quite often. And if you ever look at your balance sheet, you will find that these numbers should be on your balance sheet. So when you withhold, it goes into a liability account. When you pay it, it gets paid out of that liability account. And there should not be a balance after you pay the 403B company. So just really watch what's happening, make sure it's posted correctly. Churches don't set up a plan because they say it costs the church money. The cost is so low to set up a 403B9 plan and to maintain it. And I just feel like we need to encourage people to save for retirement. I'm just seeing too many sad stories. The other thing that people don't do correctly is they don't complete the W-2 forms. If somebody is contributing to the 403B plan, if they're a participant, meaning they're contributing or you're doing some kind of match, you need to mark that box that says retirement plan, and you need to report their amount of their paycheck deferrals in box 12. So really watch those W-2 because it matters, because sometimes people want to put money in an IRA as well, and they can't if, in certain circumstances, if they're participating in a retirement plan. And the penalty for over-contributing is 50% of what you put in. So please, get that right. Okay, everyone retires and needs funds. Please consider giving your employees the opportunity to participate in a plan. Okay, the next topic that came up this year a lot was severance. So we have severance, churches closing is the typical, not merging necessarily, but just closing. Sometimes a merger is involved, but maybe the person doesn't have a job with the new organization. Like Bob said, you got to hash all that stuff out. So severance has to be reasonable compared to similar entities in the same locale with similar characteristics. So a church with a budget of $8 million is not going to be the same as a church with a budget of $800,000. You can look at attendance, job description, years of service, education levels, but the severance has to be reasonable. And then you can also look at whether the individual was compensated fairly during his employment. I had one church that closed, and the pastor quit taking a paycheck 8 months before the church closed because he got another secular job but was still working 25, 30 hours a week at the church. And so it was reasonable to compensate him for that time that he lost when he wasn't getting a paycheck. So how do you determine what's reasonable? If you're a denominational church, I'm a Methodist, and so our denomination kind of tells us what salaries we need to pay, what benefits we need to pay, based on the person's position with the church. So if you're denominational, they'll have salary studies and that kind of thing. If you're not denominational, there's a new service that's offered by the same people who put out my favorite book, the Tax and Clergy Tax Guide, or Church and Clergy Tax Guide. And you can do that at www.churchsalary.com. There is a fee for that, but it will give you the tools that you need to determine what is reasonable. There are also professionals who do salary studies for you. This is a job that they do. And we have had churches who, in certain circumstances, have hired one of these folks. Do not call me for that because I do not do salary studies. happy to talk through the process with you, but we do not do salary studies. So you can opt to hire a professional to do one for you if there's a question. So severance is generally paid out as X weeks of pay based on X years of service. So this, church employees generally do not get unemployment. So something you need to consider is, is it reasonable to pay? If somebody's worked for you for 10 years, do we give them 10 weeks of severance? That's just an example. It's probably not appropriate to give them 6 weeks for every year of service. Appropriateness kind of depends on the circumstances, but certainly commonly I have seen 1 week for each year of service. Sometimes you see 1.5, sometimes 2, but it can include back pay if the employee was not fairly paid in the years employed, if you can prove it. So you need to look back and have the records. We're working with one church now where we're trying to determine whether that pastor was fairly compensated during those prior years. You can include a reasonable time for benefits, so maybe 90 days of health insurance or whatever it may be. I have seen up to 3 years of health insurance myself, but it depends. Again, it's very circumstantial what's reasonable. And then, as we talked about with a church 403B plan, the church can fund some contributions even after retirement. So that's a nice feature. Oftentimes, we give our employees some of their equipment that they use, like their computers, their library, maybe a car. That value of property must be considered as compensation, and it must be taxed and on the W-2 form. So it's taxed at fair market value, not what's on your depreciation schedule or what you paid for it. So if pastor's using an 8-year-old HP laptop, that probably has little or no value. But if you bought him the latest MacBook last year, that latest MacBook has some significant value. So make sure that you are tracking those things. And remember, if he used a church credit card for it, it belongs to the church. So a lot of times the library, pastors kind of look at as their library, but if it was paid for by the church, make sure that it does belong to the church. So the board has to use unbiased information, including salary studies, to determine reasonableness. And this is just something that has to be done on a case-by-case basis. If you're a smaller organization, which is under $1 million in revenue, and that's a 3-year average, you need to get at least 3 comparative organizations, and there's a safe harbor. And what that means is just that IRS has to go through certain hoops to prove you wrong. So you need to get those 3 studies, you need to rely on them, and they need to make sense. If you're getting a study from New York City for your pastor in Yuma, that's probably not fair and reasonable to rely on, so you need to make sure that they're comparable organizations. So there is no safe harbor for employers over $1 million in revenue, so it's kind of, you need to document to the IRS, should the topic come up. So you must document the date and the terms of the severance, and you need to document who was present during the board discussions and those that were recused from the discussions, and certain people definitely should be recused. You have to document in your decisions the information you relied upon, where you obtained it, keep a copy of it. Don't just say, we relied on 3 comparisons, and then somewhere that information gets lost. And then you want to document anyone not voting due to a conflict of interest. So the people that must be recused from the debate are the employee who's receiving the severance, doesn't get to weigh in on what's reasonable and fair, relatives of that employee, and I would add anyone with an apparent conflict of interest. For example, if the pastor is my best friend, should I really in good faith be voting on his compensation package? And so if there's the appearance, you may want to recuse that person as well, because it could be a conflict of interest, or at least appear to be a conflict of interest. Has to be documented. This is just so important that it be documented, because if it isn't documented, it didn't happen. So real life examples. I had a church closing. The first call was, how do we divide up what's left between all the members? That was the first question. Whoa, whoa, whoa. I said, yeah, you'll have to come to jail, to talk about that one. Okay, then it was like, okay, then we'll just give everything to the pastor. Okay, is that reasonable? No. It might be reasonable. If there's $2.98 left in the checking account, maybe it's reasonable. But just let's give everything to the pastor. And unfortunately, this church had a lot of property, and yeah. Churches merging, and this is a real case. We had that old church Bob was talking about in my church that were merging, a small one into a big one, and the original board voted to give their pastor an investment that matured in several years in the future. It was 6 times his payroll, by the way. And then the new board ratified it. And at first, we're still working on this. First glance, this doesn't appear reasonable. So, we're going to have to deal with that. So be careful about making promises that now jeopardize your tax-exempt status and cause penalties to your board members. Because when this matures, those are going to be a completely different set of board members. So be very careful about that. So retiring, let's give him his laptop and his office furniture and books. That's fine if it's A, reasonable, and B, it's on the W-2. I had a highly compensated clergy with a denominational headquarters that his advisor wanted to manipulate, lower his salary, and then have a boatload dumped into the 403B, and it just wasn't something that they should be doing. So we talked about how to do it legitimately. We talked about this one. Church closing, hadn't been paid for a number of months. Sure, we can pay him a fair salary. We paid him based on the fact that he was part-time and based on his prior salary. This is a number of years ago. We had a highly compensated pastor who died, and they wanted to pay his wife the same salary for 10 years. And she was a children's volunteer. So as a children's volunteer. So we got that one worked out with a salary study, but it was nowhere near 10 years. So rely on factual information and obtain it and document it. So if it's not reasonable, the employee has to repay the unreasonable portion plus a 25% penalty. So basically, they're responsible for 125% of what they got, or be assessed a penalty of $200,000 plus the 25. So let's see, would I rather repay 125% or 225%? Basically the decision there. So IRS is serious about this. Board members who approve the excess compensation can be assessed a penalty of 10% up to $20,000 for each transaction. And you may have multiple transactions under the IRS definitions. So this is board members who approved it, and it's a joint and several liability, meaning they can get the $20,000 from the deepest pocket on the board and not split it up evenly. So that is a concern too, as you're serving on a board. We don't want to penalize our board members. And again, if it's not on the W-2, it's automatically unreasonable. So this burden falls on you guys. If your pastors or your finance or your board is making and approving things, I've seen that. They say, we're going to pay off a student loan and it's not taxable. Well, yeah, it is. So I don't want to ever here, it's because that's what the pastor wanted. So, and reasonableness doesn't matter if it's on the W-2 form. It may be perfectly logical and reasonable, but it's automatically unreasonable if it's not on the W-2 form. So we're going to talk a little bit about parachute payments. So there's been some new taxation in the area of parachute payments, and just a parachute payment is made when someone separates from employment. So it's a payment that's made that is compensation because that person is leaving. There is a new requirement that an excise tax has to be paid if the parachute payment exceeds 3 times the average annual compensation for the 5 most recent years. So this parachute payment, while it may be reasonable, may still be subject to these excise taxes. The excise tax is 21%, but it only applies to employees who are highly compensated. $130,000 is the number for this year, and that where they're receiving more than 3 times their 5-year average. However, clergy are exempt from this because their wages are not subject to Social Security or Medicare taxes. And I have to be honest, I had a really hard time finding this because I finally went to the tax code and just drilled down really deep, and the part of the tax code that references this refers to an area where clergy wages are not included. So clergy and housing. So your clergy will not ever be subject to this parachute excise tax, unless at some point IRS figures out that a grave mistake was made in this. Because it isn't logical. This particular part of it doesn't seem logical to me. I was shocked that this was the case, but non-clergy can be subject to these. And so if you're working in a ministry that is non-clergy, you may have this. So let's just give an example of a pitfall with this thing. So let's say you have an employee who was paid $75,000 a year for 4 of the 5 years. And maybe he got some kind of like moving expenses, paid that were taxable compensation. So he had 1 year where his compensation was $130,000. So his average is $86,000, but right? So he's clearly under the $130,000. But once you hit that 130, you're forever a highly compensated individual. So any year after 2016 that you hit that, you're considered highly compensated even if you're not. So if he got a parachute payment of $300,000, then the excess of 3 times 86,000 is 42,000, and that will be subject to taxes. So the employer in this case owes the excise tax, so it would be $8,820. Now, if it wasn't reasonable to pay him that $300,000, guess what? Other penalties can apply. So just because you paid the excise tax doesn't make it reasonable. And again, if you're a highly compensated employee in any year since 2016, then you remain a highly compensated employee. So paying the excise tax does not mean it's unreasonable, and it also does not mean it's reasonable. It's distinct and separate. So these are 2 separate calculations. So again, how much care are you giving to your W-2 forms that it includes all the compensation? This is where you guys hold the key, just making sure that everything gets on there that should be. And are your salary decisions documented to protect employees and to protect your board? And if you have any of these cases, please call and talk. We're happy to talk with you. I may refer you to other professionals, but just make sure, because I've given you the high point of pages and pages and pages and pages of tax code. Okay, we are going to take a break, and I'm sorry we're a little bit over, and we will come back, and Julie Froak will be presenting bookkeeping best practices. So let's take a 10-minute break. Please visit our vendors over here, and for you folks online, we'll be back in 10 minutes. So 1050. Okay, everyone, we are going to get started again. If everyone could be seated. Our next speaker will be Julie Froak. Julie was a church business administrator for 15 years, so she sat in your position at a church, and about 6 years ago she came to our firm and has just been a real asset to our firm. She does primarily a lot of our bookkeeping cleanup, and she does a lot of tax returns. She's also studied and passed the test to become an enrolled agent by the IRS, so we're happy about that as well. So Julie will be talking to you about bookkeeping best practices.
Thank you. Before we get started, I wanted to mention that the church's live feed on the website is down. So if you have any coworkers that are watching this, you can text them because the YouTube feed is still working. So you can text your coworkers to go to youtube.com/La Casa de Cristo Lutheran Church, and that will take them to this feed. And we'll also be posting the whole webinar at a later date so that if they aren't able to get on, they can go back and watch later. Or just search for La Casa de Cristo Lutheran Church on YouTube, and that should take them to the feed. So as Monica said, I was a church administrator for 15 years, and so I truly do understand your position and the stresses and the pressures of the tyranny of the urgent. And a lot of times I think bookkeeping gets pushed to the bottom of the list when there's other urgent things happening. So I want to encourage you to not do that, not let that happen, and keep bookkeeping as a high priority. And why is that important? Your reporting, the bookkeeping that you do, influences the reports that you put together and whether they're accurate or not. And those reports are used inside your organization as well as outside. Outside may be to lenders or to ECFA type organizations. But to me, more importantly even, is inside your organization. So the decision makers in your organization are using the information that you give them to make big decisions, little decisions, maybe to add staff, to have to let staff go, to start a new ministry, or to hold back on something that maybe they want to do based on what you're reporting to them. So I guess I would encourage you to think of yourself as a key part of the decision-making process. So you're not just the bookkeeper if that's what you're doing, or your bookkeepers are not just the bookkeeper. They are a key position in the whole decision-making process for your organization. So let's see. What I'm going to talk about are some best practices for some things that we see most frequently that are done wrong. So these are problems that we see on a regular basis in our clients' books and the most common mistakes that we see. So hopefully it'll be helpful for you. One of the most common things that we see that is a problem are the bank feeds or downloading transactions. So most accounting softwares do have some type of function to download transactions from the bank website. Now this is a very handy feature, but it has a lot of pitfalls if you're not careful. And remember, our goal is to have accurate reporting for the decision makers. So you can see that if this is done wrong, you could be making bigger mistakes than what you even realize. So the most important thing in regards to downloading transactions is that you want to review every transaction before you add it to your books. So I'm sure there is a temptation to just add everything, get the bank accounts reconciled, and then maybe go back later and fix everything or edit what needs to be done. But what we see is that going back to fix things most of the time doesn't happen. So do this before you add transactions. You want to make sure that every transaction has a name. And that's important for when you go to prepare your 1099s. If you don't have names, you don't know who may need to be receiving a 1099. You want to make sure that every transaction has a correct income or expense account associated with it, or whatever type account that it needs to have. Maybe it's a liability account. But review those before you add the transactions. And then this next one, appropriate details added. I would say that most of our clients would save a significant amount of money on their billing if they did this one thing. Because when we start digging into your books to prepare a 990 or financial statements, we're having to ask a lot of questions, and there's a lot of back and forth as far as what different transactions were. So details, details, details. Those are helpful. If you're adding checks from a bank feed, you want to make sure that the check date that you're using is the date the check was written, not the date that it clears the bank. So what happens in the bank feed is going to be when it clears the bank. And for the most part, your check should already be in your accounting software if you're using the accounting or the module of your software that is for check writing. If you're not doing that, if you're handwriting checks, make sure you are manually adding those checks to your accounting software. Otherwise, your bank balance is not going to be right. So another thing that we see commonly when we're cleaning up our clients' books are duplicate transactions that happen when someone is transferring money from one bank account to another. So what happens in the bank feed is that if you're transferring from one bank account to another and you have bank feeds in both accounts, that transaction shows up as two separate transactions, one in each feed. And so if you simply just add both of them and then reconcile, you have duplicate transaction, and your bank balances and your income and expenses may not be accurate. So let me give you an example on that. Let's find here. So if you have maybe, let's see, oh, there it is. If you were to transfer from a savings account to a checking account, and then you were using bank feeds, and you may have that transaction in both of those accounts. So in the checking account, it looks like a deposit to the checking account, and it may default to an income account. And then in your savings account, it would be an expense or withdrawal, and it would default maybe to an expense account. So if you add both of those, your income is overstated and your expenses are overstated. So what you're going to do to fix that, because you're reviewing these before you add them, you're going to go to your checking feed, you're going to fix that one, and take the income account out and put the savings account there. So now the only two accounts are being affected are the checking, because it's in the checking feed, and the savings account because you've added that account to the transaction. And then you're going to delete the duplicate transaction that's in the savings feed. So duplicate transactions we see a lot, and that's one thing you definitely want to be looking for. Okay, another common place that we see errors is in credit cards. What we recommend is that you set up a liability account for every credit card that you have. So if you have 5 employees or staff members that have credit cards, you would have 5 separate accounts for those credit cards. Those are the accounts where you're going to be recording any charges to the card and payments that are made to the card. So as a good reminder, require receipts, and require receipts on a timely basis. And I'm sure if we asked most of you, this is a struggle if you have credit cards. I don't want to call out youth pastors, but I'll call out youth pastors. So if there are any youth pastors in the room, it is, if you're going to go for a receipt 3 months later and asking a youth pastor for a Starbucks receipt, probably not going to have much luck with that. So I recommend that you require receipts, make sure they follow your accountable reimbursement plan, and have a system that you set up to track the receipts, and not just on a monthly basis. As a quick example, what we did at our church was we would either download the transactions from the credit card website, or you can manually enter them, and we would just leave the description or the memo blank. If we didn't have a receipt, we didn't put anything in there. And so then Weekly, we would run a report for each credit card and sort them by the memo. So all the blanks roll up to the top, and then we would hand that. Our receptionist was the gatekeeper. So everybody has to go in and out the front door. They would pass her desk, and she would hand them the report that had every receipt that was missing for them. So find a system, whatever works for you, but stay on top of those receipts. With credit cards, you're going to be reconciling those accounts monthly. Do it timely, don't wait. The transactions that you see on your credit card should clear within a few days. So if you're reconciling and you have dated transactions that are months old, a few weeks old, you probably either have a duplicate transaction or maybe the transaction was recorded to the wrong account. Or some other type of issue, but don't finish the reconciliation until you correct and find what's wrong with that. Okay. Petty cash. This is another area that we see that has common mistakes. If you don't have a petty cash account yet, or you have one and you don't have it in your books, you want to make sure that you create a bank account or an asset account in your software that is for petty cash. And this is where you're going to track the money coming in. Probably from your bank account, you're going to either write a check to petty cash or pull out cash to put in your safe. So when you establish that, the entry that you're going to make in your software is the withdrawal from your bank account, but you're not going to record that to an expense account. Oftentimes we see that it's recorded to an expense account. And it is not an expense until the cash is actually spent. So record that to your petty cash bank account. So again, like the savings to checking, you're recording from the checking to the petty cash asset account. So like credit cards, you want to require receipts and change for any purchase that's made. Okay, so somebody needs $20 from the petty cash, make sure you follow up, you get the receipt and the change. And then you're going to record those receipts into your asset account as an expense. That's when the expense happens. Okay, when you replenish periodically, when the account gets low, when the balance is low, you're going to replenish like you started. The receipts should total up what you're replenishing. Now, that's a perfect world. We know that doesn't always happen. So if it doesn't happen, go ahead and record an over and short so that you keep that account in balance. So oftentimes, one of the things we see in petty cash is that there'll be a petty cash balance on the balance sheet, but when you look into the account, there's been no activity for 5 years. So, then we're asking questions. Do you really have $100 in your safe? Does that really exist? Are you using petty cash? What are the expenses that are being used for petty cash, and how is that, being recorded? So do use this feature. It's a good way to prevent fraud. Petty cash is a common place for fraud to happen, so having good controls and management over that is a good idea. So another area that we see as a potential for fraud is Amazon purchases. So if you're like many of our clients, you see a lot of Amazon receipts. And sometimes the problem with Amazon is that the receipt that you get from your staff member may not equal the amount that clears your bank account. And so what happens is if there's multiple items ordered on Amazon and they ship in different shipments, those are the totals that are going to hit your bank account. So you want to make sure that you keep the entries in your bookkeeping to match what's actually hitting your bank. Now, Amazon has actually improved their process, and you can get onto your Amazon website or your staff member if they are using their own, and they can actually download an invoice for that particular shipment, and that's what should balance to your books. So I know you hear a lot about missing receipts, but there should never, ever be a missing receipt for Amazon. There's no excuse for that. Because anyone's account, they can log in and they can download the receipt at any time, going back, I don't know how long it goes back, but plenty of time to get a receipt for you. Okay, so this next one, if there's one thing that you're going to take away from my module, it's this. Reconcile all of your bank accounts, your PayPal account included, and all of your credit card accounts monthly in a timely manner. So you don't want to be going back reconciling 5 years, which we have done for clients. You want to stay current on it, and you find mistakes and errors that you need to address if you stay current. So the second most important thing about this is that before you hit reconcile or finish or whatever it is in your software, you want to make sure that you follow up on any uncleared transactions. So it really doesn't do much good to reconcile your account if you're not actually going through the process to see why you have all these uncleared items, okay? So if you have checks that have not cleared for more than, say, 2 months, you want to be following up with the payees of those checks and ask them to please, cash the check. Most of the times when I had that happening, it was staff members for reimbursements that didn't get around to cashing the check, or the check was lost if it was the youth pastor, or you laugh, but you know it's true. So follow up, because 2 months now is much easier to follow up than 5 years down the road when you don't really have contact with that person anymore. And with uncashed checks, it's not simply, well, 5 years has gone by, so we're just going to avoid that transaction. By state law, you have to keep that. It's called unclaimed property by the state of Arizona. So, and there's a whole other process that goes with that you don't want to do. So follow up with the uncashed checks and get those taken care of. Okay, so as far as with debits or ACHs, those should clear within a couple days. So if you have dated transactions on your reconciliation that are longer than that for an ACH or some type of debit, you want to check and to see why, because something's wrong. It's a mistake in your books, most likely. Okay, the same would be true for deposits. If you have a 3-week-old deposit that hasn't cleared, something's wrong. So you want to research and see what's going on. It might be a duplicate, it may be recorded in the wrong account, but something's not right. Okay, so once you've cleared up all of those issues, then you're going to hit finish on your reconciliation, but not before that. Once you have clicked finish, there are some more reports that you can run that will help you find errors that you may have missed through that process. One of them is going to be an unpaid bills report. So in QuickBooks, it's called unpaid bills, but it's any type of payables report that you might have in your software that shows outstanding bills that need to be paid. So if you have dated bills, you want to ask yourself, is this bill still due? Or have I already paid this bill? Sometimes what happens is people pay their bills, they enter their bill in the payable function, but then when they go to pay it, they just write the check and they record it and pay the bill. So what's happening there is you record the payable, and that's recording the expense. Say it's your electric bill. So you record accounts payable, the expense is being charged to your electric account. And now you go to pay it and you just write a check without using your accounts payable function. Now you have recorded that expense again. So you've double recorded your expense, and back to the reporting to the decision makers, they're going to wonder why the electricity is so high. So running this report will help you keep on top of that and finding errors that way. If you do, by the way, happen to pay a bill outside of the payables function, just make sure all the details included on that check, and then just go ahead and delete the bill. Okay? The same thing can happen with your receivables. So some of you don't use receivables. A lot of times churches don't, but some do. And if you do, sometimes the same thing can happen where you record a receivable, which records the income at that time. And then when you receive the payment, you just deposit the check and you record it to income again. So if you run an open receivables report, you can see receivables that are still owed to you that people haven't paid. And you want to make sure that you don't have any of these that are outstanding. You want to ask yourself, is this still collectible, or has it already been paid? So that's, if you run that report monthly, you're going to stay on top of that as well. Okay, the next report you're going to run is the balance sheet. Monica talked a little bit about this earlier. I would say the balance sheet is probably the most underutilized report by our clients. I'm not sure why, because it's probably also one of the most useful reports. Okay, so running a balance sheet, you're going to want to look at every account on the balance sheet, every line. The balance sheet's going to tell you what you own and what you owe. Okay, so when you're reviewing each line of the balance sheet, you want to ask yourself, do these assets and liabilities really exist? And if they do, are they existing for the amount that is reporting on the balance sheet? Okay, so looking at every line is important. Other than land and buildings, if a balance hasn't changed in years, the balance is probably wrong. Okay, so do some research, dig into that account and see what's going on. The income statement, we like to remind our clients as well, the income statement, which you guys use a lot, cannot be accurate if the balance sheet is wrong. So don't ignore your balance sheet. Okay, negative amounts on your balance sheet are probably wrong. Okay, with exception to accumulated depreciation or some other contra account like that. If you have negative liability accounts, negative asset accounts, you want to look into those and see why they're negative and what's wrong with that picture. Okay. So probably the most utilized report is the income statement, and for good reason. This is going to tell you over a period of time your income and your expenses. It's very useful in budgeting and managing your ministries. You can run these reports as comparable over a period of time, so year-to-year comparative, or you can also run it as a comparative to your budget to see how budget performance is happening for all of your ministries. One thing, I was going to say review all of your income accounts and expense accounts for accuracy. So if you're looking through your income statement and something doesn't look right, it probably isn't right. So take the time, dig into it, and see what's going on. And you can see why this is important to do all of these reports monthly, following up after your reconciliations. So I want to tell a quick story about the next thing we recommend, which is reconciling your donor records to your financial accounting software. If you use a third party, a separate software for your donor records than what you have for your financial software. So I had a client early after starting to work for Monica. I was working on a 990 for a client, and I was trying to reconcile the donor records, which we always do, to the accounting software. And there was a large amount of money that was in the donor records that was not in the accounting software. So it wasn't an issue with deposits that hadn't cleared because the banks had been reconciled. So my first thought was fraud. And as I looked a little bit closer, started digging in, and this was a large amount of deposits. So not just a quick look. This is hours and hours of time. I started to see a pattern that it wasn't checks missing, it wasn't cash missing, it was actually ACH donations that were missing. So what was happening is donors were giving donations through the ACH process, and that money was never making it into the bank account. So this had been going on for a year and a half. As I looked closer, I saw there was a $10,000 donation that had happened a year and a half earlier, and that donation had never made it into the bank, and every ACH donation from that point forward never made it into the bank. So our client had been reconciling their bank accounts, and so they really had no idea they were missing $60,000. So, you know, they did end up getting a lump sum deposit from the ACH processor. It was the ACH processor's mistake, but this would be a good reason why you want to make sure. You can also catch fraud that way, but making sure your donor records agree to your, to your financial software, and doing that on a regular basis. Okay. The other thing that we recommend as well is to make sure your payroll, if you're using a third-party payroll service, make sure those records agree with what's in your accounting software. So I would say on a monthly basis, go ahead and compare those. You want to make sure wages are entered at gross. So at the end of the year, you should be able to tie your W-2s out to your software. And we do that every time we do a financial statements or we do 990s or other tax returns. We make sure those things agree. So if you did that on a monthly basis, that will help you to discover if you have any problems in that area. Okay. Some quick odds and ends. Record income in income accounts and expenses in expense accounts. The exception to that would be, like Monica mentioned earlier, if you're using a balance sheet account to track restricted funds, that's a different story. But basically, income is going to be recorded in income accounts, expenses in expense accounts. Now, if you receive a refund, you return something you purchased, you receive a refund, you're going to deposit that into the expense account that the original expense was taken from. That is not income. And likewise, if you issue a refund, say you have a student that's going on camp and they've paid, but now they can't go, so you refund that, you're going to record that against the original income account, okay? Because that's not an expense, it's just a return of the income. Merchant fees, you want to record at, record the income at gross and then record the merchant fee as a negative on the deposit or as a separate expense. But don't record the donation at the net amount received because it's not. The income is the gross amount, okay? For PayPal accounts, treat PayPal as its own bank account in your accounting software. A lot of times we see that PayPal is just entered in the software when the transfer is made from PayPal into your bank account. But in reality, you should have a bank account set up in your software that would show up on your balance sheet, and you're recording all of your income that you receive through PayPal to that PayPal account. And then monthly, you'd be recording your merchant fees, which you can pull down from the statement, PayPal statement monthly, and you're going to be reconciling those bank accounts monthly when you reconcile the other accounts. When you transfer the money from PayPal to your bank account, that is not income, okay? It's just like we talked about earlier from savings to checking. This is just a transfer from PayPal to your bank account, and that's how it should be recorded. You should have already recorded the income when you recorded the deposits into PayPal, okay? Don't use journal entries for transactions that your software has a feature for. So in other words, if you're writing a check, use the check writing feature. If you're depositing money, use the deposit feature. Sometimes you do need to use journal entries, and if you do use journal entries, they should only involve related accounts, okay? Make a separate entry with descriptions, good descriptions on each line of the journal entry for each transaction. So also with journal entries, we often see long run-on journal entries. So you may have, you know, we've seen months worth of transactions in smaller organizations entered as one journal entry with all the different accounts affected. And so it's very difficult to decipher what actually happened in that journal entry. So if you are using journal entries for entries, just use related accounts in one transaction. Don't make big, long run-on journal entries. Okay, if you're using accounts payable, make sure that you apply the bill that you're paying, apply the payment you're paying to the right bill. So if you have multiple bills for one vendor, it's very easy to apply the payment you're making to the wrong bill. And then when you run your payables report, it's not accurate and you really don't know what bills are even still outstanding. The same would be true for accounts receivable. So if you have multiple invoices for a client, you want to make sure that when they pay, you're applying that to the correct invoice. So look at dates and look at amounts and make sure you're doing that correctly. Make sure that you update memorized transactions. I see this a lot. QuickBooks has a memorized transaction feature, which is super handy, and it also will automate, so it can automatically enter those transactions without you even reviewing them. It's a great time saver. What's not a good time saver is if those keep entering and that transaction has changed in any way. So maybe it's an automatic payment you have set up at the bank for support of a missionary, and at some point you stop supporting that missionary and that ACH stops happening, but you're still entering it in your bank account or in your accounting software. So you want to maybe each month just review those memorized transactions. That's a good practice to do, and make sure you correct or delete any that aren't accurate or not happening. Now, if you're reconciling your accounts monthly, you will find these, and that's a good time to fix them as well. Okay. When to void and when to delete. We often will get this question. And I think the easiest answer is you're going to delete a transaction if it actually never happened. Okay, so for example, say you went on your credit card website to set up a payment for the credit card, and you forgot to hit the submit. I know I've done that before. I think I've paid a bill and I actually never finished that process. And you record that in your software. So when you go to reconcile, you're going to see that that transaction never cleared, and actually it never happened because you didn't actually make the payment. So that's a situation where you would just delete that transaction. You wouldn't void it, it never happened, just delete it. Okay. You're going to void a transaction when it actually did happen, but it canceled for some reason. So for instance, a lost check. If you have somebody that loses a check, you're not going to delete that in your software, you're going to void it. If you reissue the check, you don't want to just take that check, the original check, and put the new check number on it with a new date, because that basically is just deleting the old transaction. So void the check, the original check, make a note that the check was lost and that it was, reissued with whatever the current check number is, and then write the new check, okay? So in conclusion, with bookkeeping, that is something that keeps going. It keeps happening. It keeps moving forward, whether you're staying up with it or not. So my encouragement to you is carve out the time. Don't let other people's urgent situations get in the way of getting this done, because it will affect, much more than just your bookkeeping. It'll affect the decisions that are being made. If you have help, or if you need help, we're always available. We're an email away, a phone call away. Ask for help. We'd rather help you now than have to clean up 5 years worth of mess. And I keep saying 5 years because we actually have done that. So stay on top of it, and your reporting will be much more accurate for the people that are relying on you as part of the decision-making process. So thank you.
I'm almost there. Okay, our next topic is accepting cryptocurrency gifts. And in my church, we recently had a donor that wanted to give us a large chunk of cryptocurrency, and we're like, ooh, how do we do that? So let's just talk about some of the basic mechanics with cryptocurrency gifts. So how are you going to react to a donor that wishes to make a gift of cryptocurrency? It's becoming more and more popular, and it is something that I think you need to address, whether it's no, we don't accept it, or yes, we do. It shouldn't be, you should have a policy that talks about it. So through July 30th of 2021, Fidelity Charitable Fund has received $150 million in cryptocurrency gifts. They only got 28 million in 2020 and 13 million in 2019. So you can see that this is a growing acceptance of cryptocurrency. So why would a donor want to give you cryptocurrency? So there are some significant tax benefits to donating cryptocurrency. For the donor, it's treated like a property donation, so it's similar to if they donate a car or stock or other items. It's not exactly like stock, so just it's similar to. There are no capital gains taxes if the donor held on to that cryptocurrency for at least 1 year before donating it. So from that standpoint, it is similar to stock. They receive a deduction for the fair value of the currency at the date of the donation. And so cryptocurrency has increased significantly, and so they get to deduct not what they paid for it, but what it was worth on the date of donation, and so they don't have to pay capital gains tax either. So what are the benefits to the charity? So the benefits for the charity are you're going to treat it similar to a property donation. It'll be similar to a stock donation. Not exactly. There are significant differences. You can sell it immediately, and it'll provide funding for your mission. So when we talk about cryptocurrency, so cryptocurrency is the generic term, and you probably have all heard about Bitcoin or Ethereum. Those are various types of cryptocurrency. There are a lot of them out there. So then we talk about a wallet, which is Coinbase as an example of a wallet. So Coinbase is a software application. And then you have cryptocurrency processors that nonprofits can use to have the donor donate through these crypto processors, and then you receive the cash funding so that you don't actually have to handle cryptocurrency. So what are some of the reasons you might want to accept it? So you can attract a new segment of donors. We have more people using cryptocurrency, more people investing in it. It's yet another payment type. So we all have online giving now. We can donate through apps on our phone. We can accept checks or cash. We can accept stock or IRA contributions. This is yet another way for people to donate. It can boost your brand as being innovative. So cryptocurrency is fairly new. So this is something that says, hey, we get the modern world, you know, and this might be a way of boosting your brand. And it can provide a charitable solution for donors that offers big tax benefits. So those are some of the reasons that you would want to accept it. So the way it works is the donor purchases the cryptocurrency, and when you purchase it, it goes in a wallet, which is an app on the donor's computer. And then the charity needs to establish a wallet or use a third-party service to receive the donation. So these are the kind of the processes. So if you have a donor who wants to donate, you either have to secure a third-party service or do your own wallet, which we really don't recommend. What'll happen is either the charity or the third party will then sell the cryptocurrency and convert it to cash, and you could elect to hold the cryptocurrency as well. So if you didn't want to cash it in, you can hold it as an investment. Most charities will immediately convert to cash because this stuff fluctuates extremely. And so you don't want to risk losing value. So just to give you an idea of the fluctuations, these are the Bitcoin prices over the last year. So in October of 2020, it was at about 10.5. April 14th, it reached 64,000. That's 6 months, folks. And then it has dropped back down in July, and the latest date I have is October 9th, it was 54,000. So it is quite volatile in the terms of investments. So you can either establish a wallet with a company like Coinbase, and I'm not promoting any of these companies, by the way, I'm just giving you examples, or you use the third parties such as the Giving Block, Fidelity Charitable, InGiven, Every.org. So some of the risks of managing your own cryptocurrency are inherent to cryptocurrency. So the volatility of the market is one thing, that you are at the market whims with this stuff, and you can see the variations are wild. One of the biggest risks is that you would lose your digital wallet or your logins to your digital wallet. There's no 1-800 customer service number here typically. You lose it, you're done. And there's no bank you can go to, there's no FDIC insurance, there's no, you run a lot of risk managing your own stuff. They can be hacked, if your security systems aren't safe, you run the risk of a hacking situation. And they're pretty much unregulated and free from oversight. So it's buyer beware for sure on this stuff. Okay, so we talked about cryptocurrency is similar to stock in some ways. However, IRS has said it is not stock. So it's treated like other property as far as the donor goes. So there are additional reporting for cryptocurrency to the IRS. So if a donor donates more than $5,000 of cryptocurrency, the donor needs to fill out Form 8283, and the charity needs to sign it accepting the fact that they got the cryptocurrency. Now, you're not accepting to the value. When you sell the cryptocurrency, you have to file Form 8282. So that one you file with the IRS. So just to be clear here, the donor is responsible for 8283 form. They're also responsible for getting a qualified appraisal if it's over $5,000. And the charity is just responsible to say, yes, we got it, and here's the date we got it. You're not attesting to the value. You're just saying, yes, we got it. However, when you sell that, you do need to file 8282 with the IRS. Now, that is different from stock because stock has a carve-out. If it's stock that is publicly traded, IRS can easily track the dates and but they can't track it with cryptocurrency. So you want to have some best practices in regard to cryptocurrency. If you decide to accept cryptocurrency, you should update your gift acceptance policy to say how you are going to treat cryptocurrency when you get a donation. If you decide that you are not going to accept it, then your gift policy should say we do not accept cryptocurrency donations. So your policy would say we will immediately sell if that's what you want to do. And it would deal, how are you going to deal with it? Are you going to try to maintain it yourself, or are you going to use a third-party service? Again, I don't recommend do it yourself. So use a professional for this stuff. We do recommend that you convert to cash and that you comply with the different filing requirements for Form 8283 and 8282. So the 8283 is on the donor, and sometimes you don't get asked to fill out that form until the tax preparer has said, hey, did you know you need an appraisal and you need Form 8283? So you may be asked around filing time to complete that form, and that's fine. Okay. So 1099 forms. We have some upcoming changes. Some of these changes went into effect in 2020, and last year we had two different 1099 forms. You were previously used to filing 1099 miscellaneous for your subcontractors. That changed to 1099 NEC. Unfortunately, I saw a lot of churches who just used the 1099 miscellaneous again and put it in other income, and that is not correct reporting. So the 1099 NEC is for your subcontractors, and so you may need to file two different kinds of 1099s depending on your circumstances. So for example, 1099 miscellaneous, if you pay rent, you may have to put that on a 1099 miscellaneous, and if you pay a subcontractor, it may be a 1099 NEC. They have different due dates as well. The 1099 NECs are due January 31st, no questions asked. The others can be filed later. And again, we saw a lot of errors with this. So this is where the subcontractor reporting goes on the 1099 NEC. It didn't change much for 2021, so I left the same slide. And this notice box 7, that's where you used to put it. You notice you can't fill a number in there. So people were creatively using the other boxes on that form. And those other boxes mean something to tax preparers and to the IRS, so be careful that you get that right this year if you didn't do it. Okay, so there's a lot of penalties for 1099s, late filed or non-filed returns. If you intentionally disregard it, then it's $560 per return. So the penalties are pretty big. So payments to individuals or entities for services of $600 or more in a year are reported on 1099 NEC. Now, you have some exceptions to all of these. So payments to corporations or LLC entities that are taxed as a corporation are exempt. But folks, you can't tell how an LLC is taxed unless you get the W-9 form. So don't assume that LLCs are exempt from 1099 reporting, because in many cases they are not. So payments made by credit card or other third-party network payers can be excluded. So you don't need to report if you've paid with a credit card. All attorney's fees over $600 have to be reported even if the attorney is taxed as a corporation. So you report services on 1099 NEC. If you make a settlement payment for a lawsuit, for example, to an attorney's office, then that goes on 1099 miscellaneous. So attorneys are a little bit confusing for a lot of reasons. Rents paid to a property manager are not reportable. So there are some exceptions. Things that don't belong on a 1099, which I see over and over and over by churches, are bonuses, car allowances, or other payments to living employees. Those all should be on a W-2 form. Okay, your employees should not be getting both 1099s and W-2s for the same work. Scholarships do not go on 1099 forms. Purchases of merchandise. If you make a payment to another tax-exempt organization, so say you send missionary support to another 501c3, that doesn't get reported. And benevolence payments to individuals do not go on 1099 forms. Make sure that you're getting W-9 forms, because how many of you have ever gotten that letter after you file a 1099 and it says, hey, the name and the number don't match? Anybody ever see that letter? Yeah, that's the mismatch notice. And they come out typically. And typically the problem is that you've used an individual's name with a federal ID number, or you've used an LLC name with a social security number, or Bob didn't tell you that his real name was Robert, or Bud, real name is Gregory. So make sure that you have the right names, get the W-9, and ask if it doesn't look right. If there's a difference between what that person is reporting and what that, the structure of the number they're associating with it, you need to ask. Okay, so there are some proposed changes coming out for 1099 forms, and this is another area of my presentation that just felt really scrambled this year, because we had some proposed deadlines and then they changed them, and now it's kind of up in the air. But I want to let you know that this is coming. This is not going to happen. The question is, when will it happen? So as of right now, this moment, these are the proposed changes for 1099. So unless you file 250 information returns, so that's W-2s, 1099s, 1098C, which is used for donation of cars. So any of those information returns, if you file less than 250 of those, you've always been able to paper file them. So you could paper file your W-2s, paper file your 1099s. The proposed law lowers the limit to 100 for 2022, which would be filed in 2023, and down to 10 for the following year, okay? So this means that your W-2s and your 1099s and your 1098Cs and any other forms you have like that will ultimately have to be e-filed, okay? So no paper filing. So, which I think the 1098C is probably, for vehicle donations, is probably the most challenging because those have to be filed within a certain time frame after the donation. I'm not sure how all of that is going to work. So, and if you amend returns, then you have to file them in the same manner as the original. So if you paper filed it, you have to paper file amend it. If you e-filed it, you have to e-file amend it. So sometimes we do have to do amended 1099 forms. So just want to be aware of that. So to prepare for this that is definitely coming, you will want to get your ducks in a row before January 29th of, whatever year this happens. So some of the options you have is some of you have general ledger software that will allow you to e-file 1099s or W-2 forms. So I would caution you because we do a lot of 1099s where the information comes from QuickBooks, and that's well and good. But if you are not using exactly the right account with exactly the right classification, you will get a wrong answer. So it might pick up reimbursements, for example, when you didn't intend it to. So you want to review those amounts carefully. We try to use a couple different methods of, running different reports to see what makes sense for a 1099. Try to get the answer before you actually look at what the 1099 is coming up with. So you can use a third-party service like Track 1099. There are a lot of them out there. We use Track 1099, and we've used it for several years now. Really like it. You pay based on the number of forms that you're doing. The more forms you do, the lower per cost. They can even email or they can even mail the 1099s out for you. So something like that seems to work pretty well. And it remembers from year to year who you paid and that type of thing. So you can use a payroll service. So some of you might be paying subcontractors through your payroll service. So you can check with your payroll service to see what your options are for that. Or you can use an outside bookkeeper or CPA to prepare and e-file those for you. We do a large number of 1099s and we e-file all of them and have for several years now because it just is a whole lot easier, saves on postage and paper, and then they don't get lost. So that's an option. There is the IRS file information returns electronically system, the FIRE system. I read through the requirements on that, and this is not for small entities. So don't use this system. If you're going to do something, go out and get a third-party service to help you do this. I got asked about 8 times this year, how do I fill out a W-9 for our church? So this is an example of how you would fill out a W-9 so that you can give to your vendors or the people who pay you how to fill out a W-9 correctly for your church. The important thing is that top line needs to be your legal name. Now, very many churches are not using their legal name. So you might call yourself Hope Church when your real name is the First Presbyterian of Montezuma. So make sure that you're using the name that the IRS has for you. So if your 941 forms say the First Church of, that's what you should be using here. You can put a DBA in if you've registered your DBA. By the way, you should be registering your DBAs with the Secretary of State. You can put that in if you'd like. But make sure that that top name matches the federal ID number because you don't want the person who's paying you money to get the mismatch notice. So let's not share the wealth with those mismatch notices. Okay, so you've probably all heard the talk about how they're going to require $600 or more moving in and out of your bank account, and oh, woe is me, and blah, blah, blah. So this is something that has changed since I submitted my slides. That's my life these days. I feel like I'm playing catch up. So the original proposal was to lower it to $600. It's now $10,000, so down from $20,000. This is a form that you would receive. You would not issue it. So this is a form you would receive. Typically, you're just going to file it away unless it looks wrong. You know, if it doesn't look reasonable, look it over because that means somebody's collecting money in your name. But just be aware that this is a form you receive. And you will receive probably more of them, especially if you're a smaller church, you're more likely to receive it. Okay. So our next topic is one that I feel like we talk about quite often. And this is it's been a spitting match between DOL and IRS is basically what is happening here. So the question is that worker an employee or an independent contractor? That is the question. Unfortunately, our government agencies don't agree on what the actual rules are for this. So just the United States Department of Labor issued this notice 2015 in July of 15. And it relates to employees misclassified as contractors. So DOL thinks that there are a lot of employees who are misclassified. I personally do too, especially in churches. And it's entered into various agreements with states and the IRS for increased enforcement on this issue. So this thing came out and it was delayed and delayed and delayed some more. And then January 6th of 2021, now pay attention to dates here. DOL announced a new employer-friendly clarification. So what do we think happened here with that particular date? So the last remaining days of the Republican administration announced a new employer-friendly clarification of the standards, which prioritize two factors. And then on May 6th, 2021, they withdrew that rule. So you can see the change in administration in this very thing. So DOL withdrew the rule and has used a balancing approach of economic realities test and totality of circumstances. Like that is supposed to help us. So here's what we have going. We have headbutting. So now that DOL has removed that, they will revert back to fact sheet 13, which was revised in July of 2008. So we have regressed 12 years of talking about these changes. We have regressed to July of 2008. So why do we care, and why does DOL and IRS and the state care if we treat somebody improperly? So workers don't receive workplace protections like workers' comp, overtime, minimum wage. So if we have somebody who's classified as a contractor inappropriately, they're missing out. It's lower tax revenues for the government when we don't classify people. We make it unfair for those who are complying when we do things incorrectly in this area. And there can be compliance issues. For example, child support may get unpaid because, you know, the 1099 contractor, you are not submitting child support payments. There can be immigration issues associated with this and tax filing issues. So we just want to make sure that you're aware of what happens. And there's a failure to provide health insurance and unemployment benefits creates a societal burden on everybody else for whom you are not providing these benefits. So basically, And I'm just going to boil this down in a nutshell. Kind of pretty much all the agencies kind of sort of agree with these rules. It's a little more broad right now. So basically you're looking at, is the work an integral part of the employer's business? So if somebody performs the primary work of the employer, for example, they're a receptionist at your church, versus they're a software designer that manages your website. So is being the receptionist at a church an integral part of what you do? Yes, it is. The website is not an integral part necessarily, what the software designer is doing. So the work is integral even if it's just one component of the business. So your worship music leader probably under this definition is going to be integral to the church's work. They're saying it doesn't matter where the work is performed, and that especially over the last 18 months has been an issue, So, they work at home, so therefore they're not an employee. That doesn't fly. So is the relationship permanent or indefinite? So positions that are permanent or indefinite suggest that the worker's an employee, because a contractor doesn't want to sign on to something permanently and have one client. If you're in business for yourself, you want to have a variety of clients. So there can be reasons you have to look at if it's not permanent or indefinite. Maybe it's only seasonal. For example, if you're in the Midwest and you do snow plowing, there might be a reason, well, that's not going to be permanent or indefinite. It's not going to be all year round for sure, because you don't have snow all year round. So those are things that you need to look at. And if that business is only in business, is it a business decision by a contractor? So the snowplow guy has probably said, hey, I'm not going to plow snow in July. So that's a business decision of that contractor. So how does the worker's relative investment compare to the employer's investment? So the worker should have the significant investment in his own tools, his own supplies, his own equipment, his own software, everything that he needs to do his job, whether for you or for someone else. A worker, an employee, is dependent on the employer if the employer provides that stuff. So, if you're providing your, quote, contractor with a computer and software and, other things that they need to do their job, or tools or supplies, then it's most likely that person's an employee. So the worker must control meaningful aspects of the work as an independent business. So it can't just be, they control whether they want to come in at 8 or 8:15. They have to control meaningful aspects. And it has to be actual control, not theoretical. But an employer also doesn't have to be looking over the worker's shoulder to have control. So, it isn't every little step that has to be control. And you cannot base a decision on whether it's an employer or contractor solely on the control aspect. And then they look at the managerial skills. Does this person have the ability to make money based on their managerial skills at the business? So this is not, are they a great software designer? This is, are they out there marketing? Are they out there promoting their business? Are they out there serving other clients? Could they decide to fire you as a client? Because a better job has come along? So those kinds of things demonstrate a managerial skill. If you're the only client that they have, you're probably in an employee situation. So again, more of the business skills, judgment, initiative, and it has to operate as an independent business, separate and apart from the employer, and make all decisions relative to that business. So it's really important that they have a real business. Okay, factors that don't matter is where the work is performed and whether you have a contract or an employment agreement. So you can't just write an agreement that says, hey, you're a contractor, you're responsible for all your taxes, and call it good. Because if that doesn't represent the reality, then that's a problem. Whether they hold a business or other license doesn't matter. And the form, the time, or mode of pay. So whether you pay them hourly or contract, you know, a dollar amount, flat amount, none of that matters. So the Department of Labor, at least this administrator, feels that in sum, most workers are employees under the FLSA broad definitions. So, and that's been the tone since that was first written in 2008. Okay, so the IRS has its own rules. So, but they mirror somewhat. So it'd be nice if these government agencies could agree on the criteria, but so they're looking at behavioral control, whether the employer controls what is done and how it's done. They're looking at financial control, the basis on which the employee is paid, is eligible for expense reimbursements, and the worker's investment in tools. So that's very similar to how we looked at the other methods of control through the DOL. And the relationship control, whether the worker is provided benefits of any sort or is hired for an indefinite duration. So they're similar. So one thing we're likely to see in the future is what they call the ABC rules that have been adopted at the federal level. So an independent contractor is free from the control and direction of the hirer, performs work that is outside the usual course of the hiring entity's business, so again, not integral to the business, and is customarily engaged in an independently established trade or business of the same nature. So those are kind of logical rules, and basically that's kind of what the other rules say as well. So Arizona courts rule that the right to control is the overriding factor. So, and remember that the right to control is not equal to actual control. So if you have the right to control, even though you don't control, it doesn't matter. It's the right to control. So some of the areas that we see that consistently people put on contractor status, childcare workers, and I can't think of anybody more an employee than a childcare worker. Substitute teachers, sometimes we see in daycares or preschools, so hire a substitute teacher and pay them a contract. If you go be a substitute teacher in any school district in the state, you're gonna get a W-2 form. Pastors, I still see pastors getting 1099s when they are clearly an employee of the church. Not as often as I used to, but pastors get W-2 forms. They do not get 1099 forms. I see custodians and janitors where they come in, they work 5 days a week, 4 hours a day, and we call them contractors. They don't have a business because you're the only place they serve. Musicians and worship leaders, and there can be, worship leaders are almost exclusively going to be employees because they're tying into the integral part of the church, planning the worship. If you have, a brass quintet that comes in for Christmas Eve, and that's all they do, they lend themselves out and sell themselves out as a brass quartet or whatever, that's probably okay. But if you have a guitar player who's playing every single Sunday, you likely have an employee because they're tied in, that's integral to your church. Event helpers, sometimes we'll have people who come in for a big event, they set up tables, and they're not in the business of being event helpers. So you'll want to watch those folks as well. And childcare workers, oh my gosh, how can you say that they are not under the control of the church? Bob is waving at me.
Janitors and event helpers, if they are injured on the job and you have qualified them as independent contractors and not signed them up for workman's comp, you have a major problem because they will go out to the workman's comp people, get paid anyway, and then they will come back and fine the employer, and it is a disaster of expense.
Exactly. So did everybody hear what Bob said? That these people are not covered under workman's comp policies if you haven't done that, and if they're injured, you have a problem. So anybody am I correct, Bob? Anybody that we do treat as an independent contractor should have a certificate of insurance and should have a workman's comp certificate. So is that correct, Bob? You'd agree with that, right?
Yes, that means they're supplying their own workman's comp coverage, because everybody who's performing tasks on your property is going to be covered by the state. And if you haven't signed up for it and it turns out you were supposed to, then you're going to be charged anyway.
Right, right. So when you do this, and if somebody says, well, I don't have liability insurance and I don't have workers' comp, then they're probably not in business for themselves, because I can assure you I have both, and my husband is self-employed, he has both. So, you know, if you're truly self-employed, you're almost always going to have those things. So the excuses I get, I love these, I love excuses. Because it's easier. Well, of course it is. Just because it's easier doesn't mean it's right. You know, there's lots of things in life that taking the easy way out is not the right way, because they are just temporary. We don't want to hire them. Well, nothing says that you have hired, you know, because you issue a W-2 person or a W-2 form to someone who's acting as a substitute teacher, you've hired them for that day. And, you know, you can keep them on their payroll. This is my personal favorite. Well, they're just kids. So, that one, when I see, you know, 12-year-olds hired as child care workers and we're paying them on a contract basis and in the evening violating child labor laws, that just really makes me cringe when we have that situation. And because the pastor or the finance committee or the board wants it this way, well, that's lovely. They won't want the penalties that come with it. So I've heard that one a lot too. So you guys are the gatekeepers here. You guys are the gatekeepers, and you need to do your job and say when something is not right. Do you have a question?
Is there any legal obligation for you to report someone if they refuse?
If they refuse what? So the question is there a legal obligation to report somebody for hiring?
For not classifying someone as an employee?
I don't know of any legal obligation to turn other people in. You can get a reward from the IRS.
You can file a whistleblower complaint if your organization is violating the law and you try to get them to change and they won't do it, then you have a significant ability to threaten your own organization, which of course leads to several other problems that you won't be happy with. But
Yeah.
So that's not an obligation to report, but you have the right to report to insist that your organization follow the law.
Okay. So do you understand that? So you have the right to report. Sometimes, and I'll just throw this out there, sometimes people don't listen to you folks. Anybody had that case where you're just not the person they want to listen to? And sometimes I can compose an email that says, you know, we have discussed, and here, just to clarify our discussion, and oftentimes those 3 little letters behind my name, even though you're saying exactly the same thing, have more clout. And so if that opportunity comes up, that is a good way to help, because once they are notified from someone outside the organization, it really is harder to ignore. And I think the same if they got an email from Bob on a topic like that said, you know, now they might chastise you for reaching out, but I think that sometimes those little letters at the ends of our names do make a difference, even though you know exactly what should be happening. Sometimes just getting, getting those emails.
But if you are
Yeah.
You are allowing 1099 people that should be employees. Aren't you putting yourself at risk, as the fiduciary of the church?
So the question is, as a fiduciary of the church, if you're signing the 1096 form saying these people are independent contractors, if you're signing the workman's comp audit, if you're signing the 941 form, are you, and if you read the 941, under penalties of perjury, okay? So if you know that something is being done wrong, you need to advise your supervisor and you need to say, this is wrong and I'm not going to sign these forms that you're asking me to sign because it's under penalties of perjury and I know it's wrong. So any comments from our legal team here?
Yeah, that's important, and what you want to do is document that, and then, if you are reassigned, your pay is cut, or you're terminated as a result of you reporting a purported crime, then the organization has violated the whistleblower laws, and you will be compensated for that and probably reinstated, and the people who did it will be in deep yogurt.
So yes, there are whistleblower laws for this very purpose. So, be aware that you would have some protections. I don't know of any exemptions for churches for whistleblower laws, so especially where it's a financial matter. So I think that just sometimes taking a stand and armed with documentation and just saying, I'm not going to sign under penalties of perjury because we are not doing this right. And if you want to sign it, you sign it.
I'd say remember Matthew 18. I mean, this is the kind of thing that you want to approach carefully, and at first privately, and try to explain your position, explain the law to the person so that you try to be at peace within those you can, within your organization. But you are not required as an employee ever to violate the law on behalf of your employer, let alone a church.
Good questions. Can you repeat the question?
The question is, as an advisor, like a QuickBooks advisor, if the QuickBooks advisor is being asked to violate the law, she's got a much simpler answer. I don't work for you anymore.
I have many times, refused to file a tax return for somebody because they're flat out cheating. Yeah. And I have refused to file, I've told clients, well, you have to get somebody else because I won't do it. And, whatever it happens to be. So, my job as a professional is to apply my knowledge and to do returns appropriately and to advise my client when they're clearly violating the law. And I would say in most cases when I become aware of something and I email the board or the individual or whatever, it's generally not repeated. I've had some that it is repeated and they aren't clients anymore because I don't put up with it. So, I think that you need to take the steps to protect yourself primarily and make sure that, that everybody understands. But if you need assistance, that is certainly something, I will usually ask you to send me an email and then I'll answer it after we've talked, because sometimes they need to know that there are rules with these things. And a lot of it is just for those silly excuses we had because it's easier. Well, they're temporary, they're kids, because that's how we want it. And none of those are good answers. So, okay. And there are occasions where the answer is gray. I will say, sometimes it's not clear, especially when you have 3 different sets of rules, like we talked about. So sometimes it's not clear. I will say you will probably never make a mistake treating somebody as an employee as opposed to a contractor. If you're going to err and make a mistake, you want to err on the side of treating them as an employee, because I've never seen a contractor who goes to court and says, well, I was a, you know, they treated me as an employee and I'm a contractor. But there are plenty of contractors who have gone to court or to the IRS and said, well, I was an employee. I don't know why they gave me a 1099, you know. So protect yourself. So if you, clergy, get a W-2 form, not a 1099. And I say this every year. Every year. What am I going to say about Social Security and Medicare taxes for clergy? No. Clergy do not have Social Security and Medicare taxes at the employer level, ever, ever, ever. And last year, I probably amended 15 W-2s and payroll reports because we had this problem. So just, I'll say it again for the new people, that never, ever does clergy have Social Security and Medicare at the employer level. Here's your fact sheets, and I have to disclose where I got my Republican elephant and Democratic donkey. I don't want to violate copyright law. Okay. Okay, we are just about out of time. I want to do a couple questions. If you look through the 8822B information, just if you haven't ever filed one, file one now. Just read through there because you should be filing those regularly. And that's the last piece. So let's see if we can do a few questions here. Okay, the first question, oh dear, we have a lot more. Okay, this one, it comes in several variations here. Okay, oh, my drawing thing. So this one, a couple people wrote, tuition for we pay our youth ministers tuition, is that taxable? The question is, maybe. Probably, at least partially. So what you have to do is you have to look at the classes that he's taken. And I'm going to assume you don't have a tuition reimbursement plan for everybody. You've just decided to pay this one guy's tuition. So if he is taking English 101, that class does not relate to his current position. And this is his current position. If he's teaching Sermonology 101, that probably does relate to his current position. So what you do is you take the tuition costs and you split it between related and not related. And document why it's related. You should have a course description and maybe even have the employee write up how this will improve his skills in his existing job, not the job he wants, the job he has now. So if he's taking a Bible course, probably going to be okay, or, you know, but you have to take the tuition and charges and split those between taxable and non-taxable. So you can reimburse on a tax-free basis if it's related to his current job. Otherwise, the rest of it goes on the W-2. So that answer is it depends. So let's see, similar. The employee going to seminary, purchase tuition and books for him, same answer. Take those books, split them out, take the tuition and fees, split them out. And if it's directly related to the current job, then you can tax-free it. Okay, so those are 3 questions, all the same question. Okay, let's see. So there's a question here about donating extra PTO that is given to employees to another coworker who's sick. You can do that. That is allowable. Let's see. I'm not sure what this question is. It says at our discretion. You can't take people's PTO, but they can certainly donate it. So, okay, if we purchase books or resources for our pastor to keep, is this taxable income? It absolutely is. That's what I was saying. If he uses the church credit card, that stuff belongs to the church. So if you decide to give it to him, then it has to go on his W-2 at fair market value. Okay, let's see. I think we covered most of that one. And so the ERC, is it evaluated on an individual employee basis and only employees who are retained and being paid for not working? No. It depends if you're 100 or fewer employees. So if you have a partial shutdown or a full shutdown, there are a number of rules with which these employees will be eligible for this. So if you're continuing to pay them even though they may or may not be working, that's the key, is you have to continue paying them. So as long as you continue to pay people under the ERC, then you should be covered, assuming you're not 100 or more employees. Okay. We will answer all other questions that come up. Oh, I like this one too. I'm going to take this one even though. What is the purpose of depreciation in a nonprofit church? Okay. So the last 3 years, I have done forensic building projects for people who did not capitalize their fixed assets and record depreciation. And now they needed audited financial statements or reviewed financial statements because they got a bank loan. So the most recent church we did had 3 mergers and did not record any fixed assets or depreciation. And when they did record them, every time they got a new appraisal, they would adjust the balance. So, and they changed software in the middle of it, and this is why you track fixed assets. You track the fixed assets and you record the depreciation because at some point, someone is going to ask you for a financial statement under generally accepted accounting principles. And if your buildings and equipment and all of that have not been depreciated, you're going to need a major expense to get those up to date. And sometimes it can't be done. So, you know, if your church is really old or you don't have all the books and records, fortunately with this last one, they had everything and could find it, and we were able to satisfy ourselves. But that's why you record depreciation, because if you ever need to have a financial statement. And you might say now, we will never do that. And I will tell you that's probably wrong. So, okay, we're going to do a door prize. Do any of our vendors want to do a door prize today? Or, okay, come on up. So this will be for the centerpiece that is on the table over here. Frances Mincelli, yay. She came all the way from Prescott today, so we welcome her. Okay, that centerpiece is yours. No, I'll just bring this over. Okay. Do you want
okay, we're giving away a Sprouts gift card, and we're giving it to Sally Hernandez.
Ooh. And who are you with?
American Church Group.
Okay, American Church Group. Okay.
You just have to talk?
Yeah.
Okay.
We're going to go shopping together.
Okay, we're with Talentum Group, and we're giving away a box of chocolate, C's Candies. The winner is Susan Mello. Am I saying that right? Mello?
Susan here? Yay!
Hi, I'm Barbara Starley. I'm the founder of the Good Steward Church Academy, and I want everybody that is a bookkeeper, pastor, or treasurer to just stop by and give me your name, and I'll invite you into our new Facebook group where we're going to support each other and be good stewards of the money that God's entrusted to us. I'm giving away a $25 Starbucks gift card. Paul Finley.
Woo.
So we have a surprise at this time. I was so disorganized this morning, I left my house with the gift card laying on the file cabinet. So all of the 7 people who put their ticket in my box will get an email from me with a gift card. That's my penalty and a reminder to do it different next time.
Well, Bob, I blew it too, so. Okay, we want to thank you all for coming. There are leftover muffin bags over here, so please, please, please take one if you would like one. And we appreciate you coming today, and hopefully next year we can look forward to having everybody in the room. So anyway, thank you for coming. Question? Oh. Evaluations? Can you leave your evaluations on the table out front as you go? Just lay them on one of the folding tables out there. Please complete them.
My wife's a lawyer and we do a lot of lawyers. We're working with John. General ideas?
Sure.
Yes.
Do I have to do it at W-9? Send them to just to the law firm?
Just to the law firm. Whoever you make the Schmidt, Schnack, yeah. Yeah.